Good morning, everybody. Happy Tuesday. Welcome to TCF Live. My name is Dan Soul. I will guide you on this 3-hour journey through Courtlandia, starting in Lansing, Michigan. This is Judge Buchanan.
Because you didn't have to be here yesterday.
I know, right?
You've forgotten everything. We shouldn't give you a break. Clearly.
Yeah, you're probably not wrong.
I mean, technically, she's second on the list because the time slots are alphabetical. Six is seven, right?
Today's what?
Yes.
That's
It said the same. I figured. You just forgot what day it was because you had a break yesterday too.
No,
The answer is yes.
Perfect.
Yeah, that's good.
On the record in state of Michigan versus Medalo and Ensapato 2601198 SM.
Thank you, Your Honor. Cassidy Kachukas for the people, P89305.
George and APD, I have my client sitting to my left.
Thank you. And you are Medalo and Ensapato?
Yes, ma'am.
Okay. Today is the date for jury trial, and I have been handed a plea offer. This says Ms. Ensapato is being offered pleaded as charged with consent to first-time offender status. Is that a full statement of the offer?
That is correct, Your Honor.
Yes, Your Honor.
And Ms. Ensapato, that is your understanding of what's being offered to you?
Yes.
And you're interested in accepting?
Yes, Your Honor.
Domestic violence is a misdemeanor punishable by up to 93 days in jail and or $500 in fines plus court costs and up to 2 years of probation. Do you understand the maximum possible penalties?
Yes, ma'am.
You have consent to being treated as a first-time offender. So that means if you have not previously been convicted of any assaultive type crimes, you could be granted a status that lets you do a term of probation and earn a non-public record of this case. But if you've previously been convicted of an assaultive type crime, you would be sentenced without the special status because you wouldn't be eligible. Also, if you violated probation, you could lose your special status and have the crime go on your criminal history that way. Understand?
Yes, ma'am.
Some criminal convictions can have other consequences. If you are a citizen, foreign travel may be restricted. If you're not a citizen, you may be removed from the country, excluded from admission to the country, or denied naturalization as a citizen. You have the right to have an attorney, Mr. Nids representing you. You have the right to a trial. That could be by jury. Did you have an opportunity to review an advice of rights and plea information form?
Yes.
Did you sign this form today?
Yes, I did.
Have you had a chance to ask your lawyer all of your questions?
Yes.
Do you understand that if you proceed with pleading guilty today, you will give up each one of these rights? There will not be a trial of any kind. If you were on probation, parole, or bond the day this occurred, May 3rd, and you plead guilty, you could be admitting a probation, parole, or bond violation. That could result in a consecutive sentence for your probation, parole, or bond violation. You should also understand that if you proceed with pleading guilty, you will be giving up your right to appeal things that you might otherwise appeal if you were unsuccessful at trial. Are you ready to proceed with your plea?
Yes, ma'am.
Raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth under penalty of perjury?
Yes, Your
Ms.
Honor.
Ensapato, on May 3rd of 2026, were you at 3107 Fairway Court?
Yes.
Is that location in the city of Lansing?
Yes.
And was Guazani Pita there?
Yes.
Is that someone that you're married to?
Yes.
And you've lived in the same house together?
Yes.
All right. And probably before you got married, you were dating.
Yes.
Okay. And what did you do to Guazani that day that makes you guilty?
I beat him.
Beat him?
On his leg. Yes.
On his leg with what?
What?
With what? Like your hands or like a stick? Like what did you beat him with?
I bat him on his leg.
With what?
My teeth.
Oh, you bit him. You
Yes.
bit him with your teeth. Okay. Now I understand better. I'm sorry about that. And that was on purpose.
Sure, that's not a question. Did you do it on purpose? Did you mean to do it? Or was that an accident?
I was angry.
You were
On
angry.
purpose, yes.
And do you understand that if you plead guilty, you'll be giving up any claim this was self-defense?
Guilty. You're not saying this is not something else, is that correct?
Yes.
Additional questions on the factual basis?
Not from the people, Your Honor.
No, Your Honor.
Ms. Ensapato, did anyone make any promises or threats to you other than your plea agreement to get you to plead guilty today?
No.
Are you pleading guilty of your own free choice? Then to count one, domestic violence, how do you plead?
Guilty or not guilty?
I find your guilty plea to be knowingly, voluntarily, accurately made with sufficient facts on the record upon which to base your plea is therefore accepted. Sentencing will be September 1st at 1:15. We will send you to probation department to fill out a questionnaire and a risk assessment. You will have an interview later. Have an interview later that you must attend, so they can, probation can write a recommendation about your sentence, so be sure that you attend your interview. Okay, and then we'll be back here together September 1st to talk about sentence.
No.
The no contact order remains in place, no contact till further order of the court. Also going to enroll that you, or order that you enroll in class in the batter's intervention class within 14 days. They have one for women. The class is required to generally to get that special first time offender status. Class can be long, so rather than waiting till September to start class, I want you to start now. If you start the class, then I know you're serious about trying to do probation. If you don't start the class, we're gonna have to talk about whether you actually want to do probation. So it's a good indicator of your cooperation. Anything else?
Not from the people, Your Honor.
No, Your Honor.
Okay. Court officer will get you down to fill out your questionnaire and get your appointment date.
Oh. I feel you saw that.
Thank you so much. Are you ready to go on the record with Mr. Distel?
Yes, Your Honor.
When you're lawyer.
Oh, sorry.
On the record in state of Michigan versus Adam Distel, 2500573 SM.
Thank you, Your Honor. Cassidy Kachukis for the people.
George and Eddie, you can have my client, you're saying to my left.
You are Adam Distel. Today was meant to be the date for a jury trial, but it's my understanding, Mr. Ned, you have a motion.
Yes, Your Honor, I might be asking the court to adjourn this case momentarily while I actually get to sit down, and meet with Mr. Distel and get some further information from Miss Monica, who's in the back here. I got a call from her sometime last week who made some gave me some information regarding my client, which raised my concerns for potentially mental health concerns, maybe a competency issue. I want to have a little bit more time to meet with Mr. Distel, besides just having phone conversations, to better understand what's going on. And then also I have a mitigation letter I want to prepare.
It's been 7 weeks since this trial date was set.
And I just found out last week from a phone call.
7 weeks. You get one adjournment, Mr. Ned,
Understood.
and you better do something with that.
Absolutely. Again, just so you know, I got the phone call last week. I would have known about this earlier. I would have done something different earlier. Our plan was to go forward with a reasonable offer until I got that call, which raised my concerns. So there was no issues in this case up until I got that phone call, Your Honor.
7 weeks to prepare a mitigation letter.
Oh, I just got the information from her also last week. It was an email that she sent me.
7 weeks, Mr. Ned.
Just-
No,
Okay,
stop talking.
understood.
You have July 28 for trial. Provide you with a court notice in just a moment, Mr. Distel, and you'll be on your way. Stay in touch with your lawyer, and we'll be back here on July 28th.
Yep. I like that. It's fine.
You need to check the hallway for
Good
witnesses.
morning once again, everybody. It is TCF Live on a Tuesday. Good to have you all here with me this morning. Courts are a little slow to come online, but some are starting to pop up now. But we're going to continue to ride with Judge Buchanan for just a little bit as I sort through the possibilities.
And do we ever get a PSI for Dennis Hawking?
I sent you all the PSI.
My sentences today, oh yeah, here we go. Yeah, but you should have it.
Barbara, thank you for the $10. Gigi and Ellie in the house at the same time. Gigi, it's great to have you back. Dan, Cat Treat Fund. Thank you, Barbara. Very much appreciate that.
The paper copy, you can take it.
Nope. I got it.
That was sent to you on Thursday.
Yep, I got it. I put it in the wrong file. The wrong folder.
Your Honor, actually, I apologize. I did say I was only handling the jury trial, so I forgot there was a separate one. I am handling crafts.
Okay. That was a question.
Yes,
What
I
was the
apologize.
question?
And people were ready on crafts.
I don't know who's process counsel, and I was gonna start with Mr. Zaney. What I said
You
to
can
you
start with
was,
Zaney.
Yes.
do you need to check for witnesses before?
I just did and we're all set.
Okay, I know you weren't in the room for that. But that was the actual question
Yes.
was, did you need a minute? I got a half yes, I need a minute because it's not mine. Okay. Mr. Zaney, you have your client?
I do, Your Honor.
Mr. Anderson's clients. Okay, on the record in State of Michigan versus Justin Dargan, 1904992
Anna Buckingham, on behalf of the people requesting to practice under Michigan Court Rule 8.120, under the supervision of Assistant Prosecuting Attorney Cassidy Kachikis.
Is that a motion?
Yes, the request.
Granted.
Thank you.
Morning, Your Honor. Edward Zaney for on behalf of Mr. Dargan. He is present to my left.
Are you Justin Dargan?
Yes.
Okay, today is the date we set for final pretrial. What's our status?
Your Honor, the people will be nollying this case.
What would you like the reason to be drafted on there?
Necessary witnesses failing to appear.
Okay. Mr. Dargan, my usual speech is that this case will be dismissed, but could be refiled within the statute of limitations. But since it's so old, the statute of limitations might have expired already, so I guess they can't refile. And we're gonna get a copy of that. We're gonna get everyone's signature in just a moment. Right, let's see here.
Your Honor, we just asked on the Nolly that the biometric section be filled out, that it's turned completed. The biometric data.
Any objection?
No objection.
File in the hand again. Here you go. Thank you.
Thank you. Have a good day, Your Honor.
Thank you.
All right, take care.
All right, I guess Ms. Crafts is still unrepresented.
Alrighty, friends, it is TCF Live on Tuesday. My name is Dan. It is good to have you here. If you haven't already said good morning in the chat, do say good morning to us. There's 37 of you out there at the moment, and I know 37 people haven't said hi. Join the discussion. We're good people here. Let's do this. Let's go to Georgia, Fulton County, and their all-purpose calendar. This is Judge Williams.
Thank you, Your Honor. Cassidy, could you just for the people?
Well, let's try to get there. Here we go.
I see it. It just didn't travel with state of purpose. And is anyone here from probation today?
Bronner.
Good morning, Your Honor.
All right, good morning. And please tell me your name and state your name for the record as well.
Officer Kitchen.
Okay, Officer Kitchen, if possible, could you email your proposals over to, is it, Mr. Judd, are you going to do the whole probation calendar?
I'm not sure.
There's 4 people on, I think there's 4 people on there.
Judge,
So,
we won't have any recommendations for any of them, so we.
that's what I was asking. I'm just trying to figure out who's going to do it so that Officer Kitchens can send those offers over for your review.
Your Honor, if the officer can send all the recommendations to all 3 of us, I'll definitely handle with the Coney. I'll need a breakout room. I don't even know if the defendants are physically present in the courtroom.
Judge, we easy probably just put it in the chat and we can play it by ear. I mean, we'll.
Okay, this is okay. I'll just say okay. All right. Can we take another position? We're not ready on the probation yet. Those parties have not been interviewed.
We go to number 6, Mr. Bronner.
Okay, Mr. Bronner this is a bond hearing.
Good morning, Judge. Yes, I filed a bond motion for Mr. Bronner. I'd like to be heard on.
All right, Mr. Bronner, your case is 21 CR 004799C. You're charged with battery, substantial physical harm, battery, family violence, battery, simple battery, family violence, and simple battery. Do you understand your rights today?
Mm-hmm.
All right, thank you. Ms. Stallworth, can I please have the history for position 6?
Good morning, Your Honor. Yes.
Good morning.
He has 16 total. There's FTA in 2026 from Fulton, 2019 from Fulton, 09 from the city of Atlanta. There's a 2018 conviction from Fulton for purchase, possession, manufacture, distribution, and sale of marijuana, possession of cocaine with intent to distribute, and willful obstruction. And then there's an 05 first offender out of Fulton for burglary. Nothing further.
All right, thank you. Ms. Evans Battle?
Yes, Your Honor. I'm not having cooperation. I apologize. I should have had the facts pulled up.
What's his current bond?
His current bond is set at it's a cash bond, and it is set for a total of $3,000. I'm sorry, it's a surety bond. $3,000 surety. It appears to be that was set And there was no, and that was set on the battery substantial physical harm case, and there was no bond. It says bond set by judge, 0 total cash bond. I don't know what that actually means.
It's a $6,000 cash bond, Judge.
Okay.
Okay, and it may be because he failed to appear, his bond was forfeited. It appears back in his bond was forfeited September 9th of 2022 because he failed to appear for a jury trial on April the 13th of 2022. There had been previous reset for a status conference and a plea and arraignment that took place in October of 2021.
So, and then it converted to a cash bond?
Yes, and so that's why it has the cash bond. This is a case in which the victim in the case is Miss Zachary, and she is also the victim in 3 prior cases in which the defendant has entered a plea of guilty on. This took place August the 21st of 2021, and there was a dispute between the parties. They got into a physical altercation. She identified him as her ex-boyfriend at the time. He came into the home and assaulted her. She said she heard a noise of someone trying to get inside of her home from the back door, and by the time she went to check the back door, he had already entered the home. He attempted to have sex with her without permission, and by starting to pull off her undergarments, she started fighting him. He wouldn't stop, so she pepper sprayed him in the face to get him to stop. She ran and told her kids, who were also in the house, there were 3 of them, to get out of the home. Her brother was also in the home, but he apparently didn't hear anything. He indicated he heard loud noises sounded like that they were fighting. Mr. Bronner was located inside of the home, and he was washing his eyes out. She said that they normally get into fights, and most of the time it's because he is attempted to engage in intimate relationships with her, and without her agreeing to do it. So that has become it was an issue for them back at that particular time. And so those cases in which he pled guilty there were 3 of them that in which he had prior history of battery, family violence, criminal trespass, family violence as well, the property, and another battery, family violence. So that was initially, we had looked at whether or not this would be a case in which to transfer for those number of reasons, including the breaking into her home. And so our bond recommendation, of course, will remain the same at this particular time. And we did make an offer of a time served plea. Apparently he wishes not to take that.
It was just time served, or there was some additional?
There's because it's a battery, there's a statutory.
Right.
Mm-hmm.
Okay, what, go ahead and put the full offer onto the record. That was rejected, Ms. Evans.
Well, I just want to be clear. I received the offer this morning. So it hasn't been rejected. I sent a clarification email to ask if the charges were concurrent or consecutive, but also I haven't had a chance to convey it to Mr. Bronner because I'm on Zoom and he's in the courtroom. So it's not that it's been rejected, it's that I received it this morning and I haven't been able to convey it to him.
Okay, what's the offer, Ms. Evans?
Count 1 would merge with count 2. Count 2 is 12 months. Probation, serve 78 days. Credit for time served, balance probated, complete the FVIP in 40 hours of community service. Count 3 is 12 months. Probation, serve 39, it's actually 39 days commuted to time served. Counts 4 and 5 would be no pros, and there would be no objection to non-reporting.
Okay, do you want to call the jail, Ms. Pinto, and speak to your client to see if he wants to take that?
I would. What is the number that I called?
What's the number at courtroom 2 for Ms. Pinto to call?
We'll put it in the chat.
Thank you.
And then I also still, Miss Evans' battle, so are those counts concurrent?
Yes.
Okay, if we could have a brief recess, Judge, so I can speak to him.
Okay, we'll come back to you. Is there another case we can take in the meantime? Are we ready on any of the probation cases yet?
Good morning, I'm present. I think you were looking for me, so my apologies.
Someone, I think Officer Kitchens responded. Is Officer Kitchens gone? Or are you both doing calendar?
No, I'm for the probation case. She's for our intake. She's our intake.
Oh, okay, understood. Thank you. All right, are we ready on? I'm sorry. Go ahead, Milton.
Position 2 and 3, Miss Allen.
Okay, hold on one second. Did we get the probation offers? I'm sorry. Were those sent over? Did you receive anything, Mr. Haddad?
I have not, Judge. The case from Oconee County is from 2016. I assume it's going to be a time served close, but I could be wrong.
Yeah, for both probation cases, it will be continuing on probation because it's enough time to continue both cases on probation to complete the conditions of probation.
Okay, all right. So with that, is that enough information for your office to speak with the parties, Mr. Haddad?
Judge, I'll be happy to speak to Mr. The client who's in Oconee County.
Okay, so can we put those parties in a breakout, please?
And I do have the ACDC, please, Judge. I'll leave it up to the court.
Also, okay. Let's take the one ACDC plea, and then we'll put you in the breakout with Oconee. Okay.
That's fine.
All right. So we're gonna take the plea for Miss Allen. Miss Allen, if that's still the announcement. Miss Allen, you have two cases, 26 CR 003030B. In that matter, you are charged with criminal trespass. You also have an FTA. Do you understand your rights this morning? And that FTA is docketed as 26 FTA 001169. All right. Let's see. We're taking the plea, Ms. Evans panel.
Yes, Judge. The recommendation is time served, bound suspended, and stay away.
Yes, Your Honor.
No, sorry, Judge. The reason I said it is because when I spoke to Ms. Allen, that was before I got an offer. So I just want to put on the record so she's aware. I told her I suspected that's what the offer is going to be. So I apologize. I'm going to be doing that for the other ladies as well, Judge.
All right, what's Ms. Evans battle still put onto the record? Go ahead, Ms. Evans battle.
It's 12 months served, 30 days credit for time served, balance suspended. Stay away from Grady Hospital unless she needs emergency medical treatment.
No, this is the one. Stay away from the.
Oh, okay. No, I'm sorry. That's the one above it.
Right. Stay away from Budgetel. Correct.
Yes, Budgetel, and we'll not cross the FTA.
All right. Was that your understanding? I'm assuming, yes, Mr. Haddad, that was your understanding. You so stipulate to the three elements?
It is, Judge, and we're ready to proceed with the plea, Judge.
All right. Please raise your right hand, Ms. Allen, if you wish to take a plea today. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of perjury?
Yes, ma'am.
You put your hand down. Thank you. Are you under the influence of any drugs or alcohol at this time?
No, ma'am.
Did anyone force you to take a plea?
No, ma'am.
Did anyone promise you anything in exchange for taking a plea?
No, ma'am.
Did anyone, okay, and you understand you're giving up your right to trial by judge or jury?
Yes, ma'am.
And you understand you're giving up the right to have the state prove these charges, well, this one charge against you beyond a reasonable doubt?
Yes, ma'am.
And you further understand you cannot go back to that Budgetel Inn?
Yes.
All right, as to the charge of criminal trespass, how do you plead?
Guilty.
I accept your guilty plea. Is there anything additional from the state of defense?
No, Judge. Thank you.
All right. Best of luck to you, Ms. Allen. We don't want to see you back here. If you don't have other holes, they'll start processing you out. All right. Best of luck to you.
All Alrighty, good morning once again, everybody. It is TCF Live. It is Tuesday, which is better than it being Monday. Let's do this. Let's go back up to Michigan. Judge Mertz is in Kalkaska. Let's say good morning to him.
All right, ma'am, are you Ms. Bunting?
I am.
Okay. Go on the record in People versus Pamela Bunting, file number 255029. Ms. Bunting present here in the courtroom today. If I could have counsel put your appearances on.
Brian Ziegler on behalf of the people, Your Honor.
Thomas Seeger, bearing with me on behalf of Ms. Bunting.
Mr. Seeger, can you tell me the status of this file this morning?
Your Honor, I'm not entirely sure what the position of the Department of Corrections is. This was really related to court costs and fines wherein payments were allegedly not made. In any event, Your Honor, I did at one point in time speak with the Department of Corrections asking whether or not payments were made, and it sounded as though they weren't specifically made. However, when I did discuss it with her, one payment, I think of $50 had been made. However, in speaking with Ms. Bunting today, she indicated that she had made a payment today of $100. She had lost her job and was unemployed for a period of time. She subsequently just received new employment and is hopeful to be able to exhaust the matter within a period of 90 days. But I guess I would defer to the department in terms of how they wish to proceed.
Ms. Wagner?
Yes, Your Honor. She's been on probation for over a year and she's made very minimal payments. She's had employment on and off since that time. This is the only thing keeping her on probation. She's due to discharge on August 6th. She's already been extended once. I'm not opposed to extending it an additional 90 days beyond that to allow her to pay. I think if she's not paid in full by that date, we probably need to move on with a sanction or something. This is the only thing keeping her on probation.
Okay. Ms. Bunting, what's your current situation?
I just got a job making $27 an hour daily pay. So every day I work, I will be making a payment to get it paid off quick.
Okay. All right.
It's like a 1099 self-employment type of thing.
Okay.
So every day that it's at the end of my day I work, I get paid Cash App or Venmo, and I'll probably have to pay it online because I won't make it in time to pay cash. But
Is this a pretty consistent?
yeah, yep.
What kind of work are you?
It's housekeeping.
Oh, okay.
Yep.
All right. Is it like, are they one-time jobs, or do you have like work every single day?
Almost every day.
Okay.
Yeah. Especially on the weekends, probably like every Saturday at least. But I know like I work tomorrow, so I make a payment tomorrow, and then I work Friday and probably Saturday. I'm not sure after Friday what my schedule is, but.
Okay. And is this like private residences? Is it like resort?
It's a resort. I don't know if you heard of Spider Lake in Traverse City.
No.
Well, anyway, it's like a resort, and then we have houses all over the place that we all go to. So it's pretty consistent, except for in the wintertime, obviously. But yeah, it's pretty decent. So.
Okay. All right. Then Ms. Wagner, I'd like to go forward as you suggested, to continue monitoring Ms. Bunting's payments and extend for 90 days. And then we'll see where we're at that point.
Okay, thank you. Can we put her back on the docket then in 90 days just to keep it going?
Yes.
Unless she's paid in full. If she's paid in full by that date, I'll submit the discharge to the court.
Right. Okay. Exactly.
Thank you.
So Ms. Bunting, just make sure you stay in touch with Ms. Wagner.
Okay.
Did you have any questions at all?
No, I was just gonna see if I had to let her know when I had them paid off and stuff and go from there. But I guess by the sound of it, that's what I need to do. So.
All right. Thank you.
All right. Thank you.
Alrighty, friends, let's move out of Michigan, at least for the moment. We will go down to Florida. Say good morning to Wade Mercer. Check in with him.
Mr. Dickens, good morning. Mr. Dickens, I'm Wade Mercer. I'm the county judge. You also probably be able to see our prosecutor, Mr. Jake Mitchell, in the courtroom. I know that you can see and hear Mr. John McDaniel, Assistant Public Defender, standing next to you. Mr. Dickens, you've got one new charge. You're accused of one count of resisting an officer without violence. There is probable cause in that complaint. In addition to that, you have a pending misdemeanor, failure to appear warrant in 26302 MM and a failure to appear in felony case 25575 CF. Mr. Dickens, first of all, I'm going to revoke your bond in case 25575 CF. So I'm going to ask Mr. Mitchell to get me an order revoking your bond based upon yesterday's arrest. So you no longer have a bond in that case. Be aware of that. In your two misdemeanors, both the old one and the new one, I'm appointing the public defender's office to represent you. I'm going to ask that you listen to Mr. McDaniel, your attorney.
Your Honor, I spoke to Mr. Dickens in 26302 MM. He's going to plea of no contest to the charges listed. In the new case of resisting without violence, he's going to plea of no contest in that case as well. Understanding is going to be 60 days in the county jail. We have 1 day jail credit. There'll be a fine of $722 in 26302 MM, fine of $370 in resisting without violence. So both run concurrent with each other. So he has signed his three-way form waivers right to jury trial and call witnesses.
Thank you. Mr. Mitchell's had agreeable with the state.
It is, Your Honor. I guess for clarification, wasn't his bond already revoked in the felony case for a failure to appear?
No.
It wasn't
just a
official.
failure to appear.
Until.
That's totally different than the bond revocation.
Okay. I was just making sure, but I will get you the proposed order in today.
Let's double check. Typically, a bond revocation is different because if a judge sees that, they're much less likely just to reinstate it. A failure to appear, if you have a valid reason for a failure to appear, you may be entitled to the warrant being set aside. That's not true with a bond revocation based upon a new arrest. So no, that bond has not been revoked.
Okay. Just making sure. I'll get you the proposed order in today.
Thank you. So Mr. Dickens, did you hear that agreement, sir?
Yes, sir.
Is that the agreement you would like to enter to resolve these two misdemeanor cases?
Yes, sir.
Mr. Dickens, I'm going to accept your plea of no contest to that one count of assault in 26302 MM and the charge from yesterday, resisting an officer without violence. I'm going to judge you guilty of those two misdemeanors. I'm going to sentence you to 60 days in jail on each case concurrently. Mr. Dickens, that means they're running at the same time. Court costs and fines are imposed, Mr. Dickens, of $370 in the resisting, $722 in the assault, 1 day credit in both cases. Mr. Dickens, you certainly may do less than the 60 days, but keep in mind, you've got the holds on you that I've already mentioned. So even if you've got to deal with this, so you may resolve the felony cases before you resolve this, or vice versa. You've got to resolve all cases to be released. Mr. Dickens, do you have any questions?
No, sir. Thanks.
Wish you the best. Wish you the best, sir.
Thank you.
You're welcome, man. Is that a case for this morning? Sir, come on, let me see your paperwork, please. Mr. McDaniel, I think we're through with the jail. We've got a gentleman in the courtroom and we'll see what paperwork he has here. Corporal, anything else from the jail this morning?
No, Your Honor.
Is that a DL return?
Sir, come on up. This is Danavia Sampson. Mr. Sampson, tell me, I'm not sure I don't have your name on our first appearance list, so tell me what's going on. I've got a first appearance paperwork that tells you to be here. So did you post bond? Did you get arrested?
I got arrested on a Sunday, got out Monday morning.
Where were you arrested at?
Justice County.
Okay, and you posted bond?
Yes, sir.
You got out Monday?
Yes, sir.
And you were given a notice to be here today?
Yes, sir.
Who gave you that notice?
I got it from the jailhouse. That would come from the jailhouse.
Corporal Danavia Sampson, arrest date June 28th. He's got a written notice. It says 7/7/8/30. Will you check the docket down there? See if it's got to be another courtroom.
Hold on. Oh, wait.
Yeah, that's probably going to be felony court. We got felony court today.
That's my guess too.
But the felony, this would have been after the cutoff though. So it looks like somebody at the jail gave him a notice for a wrong date. That's what it looks like to me. His court date in the file is August 4th, not today. So Dawn, if he came to first appearance on the 29th.
No Sampson down there.
29th. I'm sorry?
Nobody down there.
He came to court on the 29th.
What's his case number?
Say that again. They gave him the right date then? That's what.
Yeah, that was the cutoff date.
I wonder why the clerk would have it set up for August instead of July. Okay. So Gary, we need to get Mr. Sampson down to the other courtroom and get it to Jeannie down there, and they can give us, I think you may be in the other courtroom, sir. They're gonna try to get it figured out, okay? Okay. Please. So if they can tell them that according to our notes, that was the cutoff. So the jail gave him the right day, Stacy. Tell them that it looks like the jail gave him the right day from our dates. Okay. And if he did, they need to try to add him to that docket since he's here.
Yes, sir.
If they didn't give him the right day, we need to figure out what happened. It looks like
it is a felony case.
That doesn't make any sense to me. Looks like
6:30 by the looks of it is when he was first appeared.
6:29.
6:29, yeah.
Which was the cutoff, right? All right. So Corporal, looks like y'all gave him the right date. Looks like the clerk's office set him for the following month. We'll let them figure it out. I don't know.
Yes,
Anything
sir.
else this morning, Corporal?
No, Your Honor.
And it's Judge Grammer at 8:30 tomorrow?
Yes.
Okay. Anything else from the state?
Nothing from the state.
Short day for Judge Mercer, though a confusing one, kind of a quasi-Monday. Let's go back up to Michigan, Judge Hunter.
I'm not on the record yet, gentlemen, but that's because I haven't identified Mr. Lawrenson. Sir, are you David Calvin Lawrenson?
Yes, I am.
Okay, thank you. The attorneys knew who you were. I didn't. That's why I always start the record by making sure I know who's in place. The attorneys are here for this case. Mr. Lawrenson, you're in the Otsego County Jail. Despite that, have you been able to maintain good contact with your attorney?
Yes, Your Honor.
Thank you. Mr. Matisse, then what should the court be aware of regarding the status of this case?
Your Honor, if the prosecutor would put the offer on the record, we believe we've reached a resolution in this case.
Okay.
So, excuse me. The offer in this particular case is to enter a plea as charged in count 1 and count 2. And in exchange for that, count 3, 4, and 5, and the habitual offender second notice would be dismissed.
Is that an accurate statement?
That is, Your Honor, and we'd like to accept that plea.
All right, thank you. Mr. Lawrenson, did you understand the terms of the plea agreement?
I believe so. So the habitual offender was dropped on both charges.
That's right. So you would be pleading guilty to count 1, operating while intoxicated, third offense. That's a felony. And count 2, police officer, first responder, assault, resist, or obstruct. That's also a felony. The OUI, third offense, is punishable by a maximum of 5 years. The resist and obstruct charge is punishable by a maximum of 2 years. And everything else that's been charged in this case would be dismissed. You understand that?
Sure. Thank you.
Is that what you want to do, is plead guilty under those terms?
Yes, I do.
Raise your right hand, please. You solemnly swear or affirm the testimony you're about to provide is the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
So, Mr. Lawrenson, again, in this plea agreement, you would plead guilty to the offense in count 1, known as operating while intoxicated, third or subsequent offense notice. That offense is a felony offense. The minimum fine is $500. The maximum fine is $5,000. And the court has several different sentencing options. I could sentence you to 1 to 5 years in the state prison system, or more than 1 to 5 years in the state prison system, 5 years max. Or I could put you on probation with 30 days minimum in the county jail, up to 1 year in the county jail. At least 48 hours of your sentence must be served consecutively. The court also has the authority to sentence you to a minimum of 60 days, up to 180 days of community service. And I can't order you to engage in rehabilitative programming. I can order you to pay the cost of prosecution and to reimburse the government for emergency response. And finally, there is mandatory vehicle immobilization of not less than 1 year and not more than 3 years. Do you understand all of those items?
Your Honor.
Count 2, you would be pleading guilty to police officer or first responder assault, resist, or obstruct. That also is a felony offense. The maximum punishment for that felony offense is up to 2 years in the state prison system and or a fine of up to $2,000. Further, a consecutive sentence could be imposed under one statute if the assault was committed in a place of confinement, or under another statute for another violation arising from the same transaction or occurrence. Are you aware of that?
Yes, Your Honor.
The benefit of the plea agreement is if you plead guilty to count 1 and count 2, the prosecutor would dismiss the habitual offender second offense notice, and the prosecutor would dismiss also each of the other charges that were filed. So counts 3, 4, 5 as well. Do you understand the benefit?
Yes, Your Honor.
Understanding the benefit of the plea agreement and understanding the maximum penalties you could face, how do you plead to count one operating while intoxicated third offense?
Guilty.
And how do you plead to police officer, resist, obstruct, or oppose?
Guilty.
If you plead guilty, you no longer have any automatic rights to appeal. Do you understand that?
Yes, Your Honor.
Instead, you would have to ask for what's called leave to appeal, and that could be denied. If you plead guilty, you also give up all of your current trial rights. The trial rights include the right to be tried by a jury of your peers, the right to be presumed innocent until you're proven guilty, and the right to have the prosecutor bear the burden of proving you're guilty beyond a reasonable doubt. At your trial, you'd have a right to have the witnesses against you appear and to see, hear, and question them. You'd also have the right to have the court order any witnesses on your behalf be ordered to appear at trial. You have a right to remain silent during your trial and not have that silence used against you, and you would have the right to testify at trial if you wanted to. But if you plead guilty, those trial rights are gone. Do you understand that?
Yes, Your Honor.
And because you're giving up your right to trial itself, you also necessarily give up the right to challenge other things that you might have been able to challenge if you did have a trial. Do you understand that?
Yes, Your Honor.
Outside of the plea agreement, has anyone promised you anything to get you to plead guilty?
No, Your Honor.
Has anyone threatened you in any way to make you feel like you have to plead guilty?
No, Your Honor.
Are you pleading guilty freely and voluntarily?
Yes, Your Honor.
Is it your choice to plead guilty?
Yes, Your Honor.
Prosecutor claims that this offense happened on or about March 5th of 2026. Do you think that date is accurate?
Yes, Your Honor.
On that date, had you been operating or did you operate a vehicle upon a highway I-75 here in Otsego County?
Yes, Your Honor.
At the time, were you under the influence of alcohol?
Yes, Your Honor.
How much alcohol had you consumed?
I'm not really exactly sure.
Did you
I had a
take
few
a
drinks.
blood test?
Pardon me?
Did you take a blood or breath test?
I did not. I took a blood test. I'm not aware of the results.
Counsel, do you have a stipulation as to the results?
Judge, I'm pulling that up now. We have discussed it, but sorry, Judge, I'm trying to get it.
It was a .322, Your Honor.
Yeah, it was. I was right around that. Yeah, that's right, Judge.
All right. And did you hear that result, Mr. Lawrenson?
Yes, sir.
Do you have any reason to dispute that result?
I do not.
And so obviously you agree you were intoxicated at the time you were driving. Is that true?
Yes, Your Honor.
Is it true that you were previously convicted of an operating while impaired offense on or about December 15th of 2004 in the 50th District Court in Pontiac?
Yes, Your Honor.
You also convicted of a separate operating while intoxicated offense on or about March 8th of 2005 in the same in the 52nd District Court in Rochester Hills.
Yes, Your Honor.
Did you come into contact with police on that date?
I'm sorry?
Did you come into contact with police on that date?
Yes, sir.
Was one of the officers an officer with the Michigan State Police known as Sergeant Ronald Medalo?
Do not remember.
That's fine. And that fact that you don't recognize his name is okay, but in any event, you knew that the officer was in fact a Michigan State Police officer, correct?
Yes, Your Honor.
You agree with that he was lawfully performing his duties?
Yes, Your Honor.
What did he tell you to do, or what did you not do that makes you guilty of resisting or obstructing?
I'm not really sure. I know I was acting outside of my character that day, and I'm not sure what I did to draw the charge, to be perfectly honest with you.
Mr. Lawrence, you were offering to plead guilty to a felony offense and you don't know why you're guilty of it?
Well, I was informed of my actions that day.
Do you not remember because you were so intoxicated?
A few things are a little blurry. I do remember that I was acting up in the police car and they had to pull me out.
When you say acting up, do you mean that you were being combative and you were impairing the officer's ability to do their job lawfully?
Yes, Your Honor.
Counsel, does that satisfy you, or would you like an opportunity to inquire of Mr. Lawrenson further?
Judge, I believe Mr. Lawrenson has met the factual basis there when he tells us that he was non-cooperative with the officers in the back of the car.
Mr. Fortier, do you agree?
I do.
Do the attorneys believe otherwise there is a factual basis also for count one and for count two?
I do, Your Honor.
Do Do the attorneys believe the court has complied with the court rule regarding the taking of pleas?
I do, Your Honor.
Yes. Yes, Your Honor.
Are either one of the attorneys aware of any promises, threats, or inducements not disclosed up?
No, Judge.
No, Your Honor.
Mr. Lawrenson, based upon your statements, the court finds that your plea is knowing, voluntary, and accurately given, and there is a clear factual basis to find you guilty of count 1 and count 2. So the court will accept that plea and enter it on your record. The next step is the department will interview you there in the jail. The purpose of the interview is to create what's called a pre-sentence investigative report. That will tell me more about you and more about this event before I impose sentence. You need to go over that document very carefully with your attorney. Then I'm going to bring you back here in person for a sentencing hearing, meaning your attorney, the prosecutor, myself, and you will all be here in the courtroom. Do you have any questions about any of that?
No, Your Honor.
Mr. Fortier, anything further?
No, Your Honor. Thank you.
Mr. Matisse, anything further?
No, Judge.
Okay, thank you. You're all set today, Mr. Fortier, or Mr. Lawrenson?
Thank you, Your Honor.
Thank you.
Alrighty, friends, just under an hour into TCF Live already. Time flies as it always does. Let's go to Lake County, Ohio. Judge O'Donnell. Let's see who he's going to swear at this morning.
Is to commit aggravated murder. There will be a 3-year firearm specification to count 14.
Maybe not, friends. His feed is choppy. That's not us. That's him. Let's go back to Judge Hunter for now.
Immediately just provided information, but do you have any reason to dispute the fact that it may be that Mr. Hauser is lodged in the Ogama County Jail?
No, Your Honor. I don't have any independent information that would lead me to believe otherwise.
So, Mr. Dick, what I want you to do, and I accept your statements as an officer of the court that that's what you just found, but is I want you to forward that information to the clerk's office and to Mr. Fortier. If there's any reason to challenge the accuracy of that information, the court would certainly consider a bench warrant. But because it appears that he is lodged in the Ogama County Jail, my suggestion is we simply reset this matter and have it written prepared. Mr. Fortier, given the statements on the record, do you oppose that?
No, Your Honor. In our office will, if he's still in the jail at the next appearance, we will prepare a Zoom writ.
Thank you. Mr. Dick, any problem with that procedure?
No, Your Honor. I will get that information to the court, Mr. Fortier, right away.
Thank you. So the court finds your cause to adjourn then. Mr. Barr is in my waiting room. I'm bringing him in next.
All right, friends, we can try Judge O'Donnell again. It looks like the feed is smoothed out, but let's give it a try.
Enter a guilty plea here to today. Thank you.
Thank you, Mr. Parker. Thank you, Your Honor. That is my understanding of what the plea agreement is. I've had the opportunity to go over this offer with Mr. Gaston. I've discussed with him the potential penalties for all of these offenses that he would be pleading guilty to. I've gone over his criminal rule 11 rights, the rights he would give up by entering a guilty plea, and I've also had extensive discussions with him about the discovery that was provided to me by the state. Based on all those conversations, Your Honor, I do believe it's his intention to accept the offer from the state and
All right, Mr. Gaston, how old are you?
20 years old.
How far did you go through school?
12th grade, graduated.
Are you a U.S. citizen?
Yes, Your Honor.
Are you able to read, write, and understand the English language?
Yes, Your Honor.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication within the last 48 hours?
No, Your Honor.
You ever been diagnosed with or treated for any mental illness?
Yes.
Did you get a copy of this indictment?
Yes, Your Honor.
It's my understanding you're going to plead guilty to 1, conspiracy to commit aggravated murder or felony 1, as well as a firearm specification of count 1. Count 4, felonious assault as amended, a felony of the 2nd degree. And count 25, discharge of a firearm on or near a prohibited premises, a felony of the 3rd degree. and then the remaining counts will be dismissed at the time of sentencing. Is that your understanding?
Yes, Your Honor.
Any questions about that?
No, Your Honor.
All right, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. So I'm going to ask you some questions. If you don't understand a question, let me know that. If you want to talk to Mr. Parker some more, let me know that, and I'll give you more time. You understand that?
Yes, Your Honor.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. You understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes, Your Honor.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine those witnesses. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you go to trial, you have a right to have witnesses come here and testify for you. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If those witnesses refuse to come to court, I'll issue an order that's called a subpoena to make them come here and testify. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
You have the right to testify at trial if you want to. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes, Your Honor.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you could not afford to hire a lawyer, one would be provided at no cost to you. Do you understand that?
Yes.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes.
If you could not afford to hire a lawyer, one would be provided at no cost. Do you understand that?
Yes, Your Honor.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes, Your Honor.
Do you have any questions about any of these rights?
No.
Do you still want to plead guilty to these 3 counts?
Yes, Your Honor.
Do you understand by pleading guilty, you're fully admitting your guilt to the charges?
Yes, Your Honor.
You understand by pleading guilty to these charges, you're voluntarily giving up your freedom for whatever period of time that I sentence you to prison.
Yes, Your Honor.
In count 1, conspiracy to commit aggravated murder is a felony of the 1st degree, and it is what is known as a qualifying offense. And with that, there is a maximum prison term on that count of 11 years. That is the definite minimum. It's a maximum you can get on that charge is 11 years, up to an indefinite maximum of 16 and 1/2 years. Do you understand that?
Yes, Your Honor.
Now, whether you serve any additional time beyond the minimum, there's a presumption you should be released at the expiration of that minimum, the definite minimum term. If you are not, then you are entitled to have a hearing to determine whether you should be released. Do you understand that?
Yes, I understand.
Whether you are released or not at the minimum is dependent upon the criteria established by the Department of Corrections, based in large part on your activity while you're in the institution. Do you understand that?
Yes, I understand.
Do you have any questions about how that definite minimum and the indefinite maximum work?
No, Your Honor.
Right. There is also a potential fine of the maximum of which is $20,000. Do you understand that?
Yes, Your Honor.
There is a firearm specification attached to count 1, and that requires a mandatory 3-year prison sentence that is to be served prior to and consecutive to the underlying offense. Do you understand that?
Yes, Your Honor.
On count 14 is amended, that is felonious assault, a felony of the 2nd degree, carries a maximum prison term of 8 years and a maximum fine of $15,000. Do you understand that?
Yes, Your Honor.
Count 25, discharge of a firearm on or near a prohibited premises, is a felony of the 3rd degree, and that carries a maximum prison term of 36 months and a maximum fine of $10,000. Do you understand that?
Yes, I understand.
Now, I could give you a consecutive sentence. That means one sentence after another for the separate offenses. If I did that, you face a prison term. The maximum would be 25 years up to an indefinite maximum of another 5.5 years or 30.5 years. Do you understand that?
Yes, I understand.
And the maximum fine would be $45,000. Do you understand that?
Yes, I understand.
All right. There is, in addition, as I told you, the firearm specification is mandatory. There is a presumption that a prison sentence should be imposed on the count 1 conspiracy to commit aggravated murder, as well as felonious assault. Do you understand that?
Yes, I understand.
Are you presently on post-release control to the parole authority?
No, sir.
Do you understand that your felony conviction will prevent you from owning or possessing a firearm?
Yes, Your Honor.
Do you understand that upon your release from prison, you will be on post-release control for at least 2 years, up to 5 years, under the direction of the adult parole authority?
Yes, Your Honor.
They will place conditions upon you. If you violate the conditions, the parole authority could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes, Your Honor.
If that violation of post-release control is a new felony, then you could get an additional consecutive prison sentence for that violation. Do you understand that?
Yes, I understand.
And if that were to occur, the maximum prison sentence for that violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes, Your Honor.
Do you understand that with regard to this prison term, after the mandatory portion of that prison term, you are eligible for judicial release?
Yes, Your Honor.
Now, has anybody promised you that I would be lenient on you just because you're pleading guilty today?
No, Your Honor.
Has anybody promised you what I will sentence you to in this case?
No, Your Honor.
Do you understand I do not have to follow the sentencing recommendation of either the prosecutor or your lawyer at the time of sentencing?
Yes, Your Honor.
Have you had enough time to talk with Mr. Parker before pleading guilty today?
Yes, Your Honor.
Has he discussed everything about your case and answered all of your questions?
Yes, Your Honor.
Are you satisfied with the advice he has given you?
Yes, Your Honor.
Have you been threatened or coerced in any way to plead guilty today?
No, Your Honor.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes, Your Honor.
Do you have any questions at this time?
No, Your Honor.
All right. Ms. Blake, if this case went to trial, what would the evidence show?
Thank you, Your Honor. Had this matter proceeded to trial, the state would have proven the following beyond a reasonable doubt. As the court is aware, the indictment is fairly thorough in this case, as is count 1 specifically. These events occurred on June 7th, 2025, in the city of Painesville, Lake County, Ohio. Solomon Gaston, the defendant, he did conspire with others, including Aviante Atterbury, Avion Gaines, Zyder Jackson, and Lakeisha Jackson, to kill William James Sheffy Jr., and that did happen on June 7th, 2025. It involved a day-long course of conduct. That course of conduct is outlined thoroughly in the overt acts in count 1 of the indictment. Mr. Gaston was involved in vehicular pursuits, essentially, of Mr. Sheffy throughout the day. Early in the day, he was in his own vehicle, but for much of the day, he was a passenger in either Aviante Atterbury or Avion Gaines' vehicles. This all culminated, Your Honor, shortly before 8 p.m. at Erie and Rockwood in Painesville City, where Will Sheffy was met by Zyder Jackson, Avion Gaines, and Aviante Atterbury, and was a passenger in Aviante Atterbury's vehicle. At that time, Aviante Atterbury, Avion Gaines drove head-on at Mr. Sheffy, while Zyder Jackson, with his mother as a passenger in that vehicle, was chasing from behind. That forced Will Sheffy down Rockwood. Rockwood exits to North State. As Mr. Sheffy drove down Rockwood, Avion Gaines pursued from behind down Rockwood. Zaire Jackson had turned around and met Will Sheffy at Rockwood and State, as did Aviante Atterbury. The state would have proven that Aviante Atterbury had provided a firearm to Solomon Gaston, who was a front seat passenger in his vehicle, and had ordered him to be prepared to shoot at Will Sheffy. That did happen at Rockwood and State after Will Sheffy was blocked in. He was shot and killed by Aviante Atterbury. During that time, Your Honor, Mr. Gaston did discharge the firearm provided to him by Aviante Atterbury in the direction of Will Sheffy's vehicle. When that happened, he did endanger the lives of the two occupants of that vehicle, Jeffrey Lee and Brent Adams. He also discharged that firearm over a roadway, thereby placing the public at a substantial risk of physical harm, including two other individuals who were mentioned as victims in the indictment, but not in the counts that Mr. Gaston is pleading to. Those individuals were Alejandro Gonzalez Ramirez and Juan Padilla Reynoso. Your Honor, that firearm that Mr. Gaston was provided was clearly operable. That was observed through crime camera footage and evidence that was collected at the scene. Will Sheffy did die as a result of the one gunshot wound sustained to his head that again was administered by Aviante Atterbury. Had this matter gone to trial, that is what the state of Ohio would have proved beyond a reasonable doubt, Your Honor. Thank you.
Thank you. Mr. Parker, anything to add to those facts?
Your Honor, Ms. Blake's recitation is accurate. Nothing further to add. Thank you.
Right. Mr. Gaston, did you hear what Ms. Blake said that the facts would show if this case went to a trial?
Yes, Your Honor.
And are those facts true?
Yes, Your Honor.
All right, what is your plea to count one, conspiracy to commit aggravated murder, a felony one?
Guilty.
What is your plea to the firearm specification to count one?
Guilty.
And what is your plea to count 14 as amended felonious assault, a felony 2?
Guilty.
And what is your plea to count 25, discharge of a firearm on or near a prohibited premises, a felony 3?
Guilty.
Mr. Parker?
Before, okay? You see, it's the same stuff. All the same as we went over, remember? So sign there. And today is July 7th, 7/7/20.
Review the written plea of guilty and judgment entry. I do see their signatures to the document at this time as well. With permission of the court, may I approach?
Yeah.
Thank you.
All right, Mr. Gaston, is this your signature on the written plea of guilty? And do you want me to accept your written plea of guilty?
Yes, Your Honor.
I'll accept the written plea of guilty. Defendant was present when Mr. Parker advised of all of his rights in a knowing, intelligent, and voluntary waiver. Only find it to be knowing, intelligent, and voluntary. I will accept the plea of guilty and find the defendant guilty of count 1, conspiracy to commit aggravated murder, a felony 1, guilty of the firearm specification of count 1, guilty of amended count 14, felonious assault, a felony 2, and guilty of count 25, discharge of a firearm on or near a prohibited premises, a felony 3. I'll refer this for a pre-sentence report and victim impact statement. Sentencing will be August 28 at 10 a.m. Anything further, Ms. Blake?
Nothing from the state, Your Honor. Thank you.
Parker?
Nothing from the defense either. Thank you, Your Honor.
All right, we're adjourned.
All right.
A choppy stream, but we got the point. That probably could have been a lot worse for that young man. Hopefully we'll be able to get to see his sentencing and see how this all ends. Okie dokie, friends, now in hour 2 of TCF Live on this fine Tuesday, where here in the desert we're going up to like 111 degrees or something like that today. Basically, it's that you're going to catch on fire if you walk outside kind of temp, so looking forward to that. Let's go to Louisiana, checking on the board.
Morning is review and approval of our meeting from yesterday, Monday, July 6th. Those minutes are included in your packets this morning. Are there any corrections? I would like to entertain a motion to approve the minutes.
Second.
We have a motion by Mr. Phillips, second by Mr. Freeman to adopt the minutes as presented in the agenda. Here is on the minutes are approved. As we move through our agenda today, we will allow public comment on requests before any action is taken. Would you call the roll, please?
Ronaldo.
Here.
Staten.
Here.
Prater.
Here.
Tillis.
Here.
Freeman.
Here.
Madam Chair, we have a quorum.
Thank you. I failed to do that at the onset, so we're ready to begin consideration of our applications for clemency. And our first case is Mr. Juno. Good morning.
Good morning.
Would you introduce yourself, sir? Tell us your name and current mailing address.
Yes, ma'am. Jody Juno, 4168 Bank Street, Esmer, Louisiana 71341.
Thank you. And you have your counsel with you
And
this
I
morning.
apologize for interrupting, but I just learned he has a new phone number, so anything we gave you before may be inaccurate.
I have one ending in 4819.
I'm sorry?
I have a phone number ending in 4819.
That's it.
Okay, yeah, we have the right one.
597?
Yes.
Yes, ma'am.
Okay.
That's the one.
Counsel, would you introduce yourself for the record, please?
Demetrius Burns, counsel for Jody Juno.
Thank you and welcome. And we have Miss Wanda Nolan also with your firm, I believe, that's here as well.
Mr. Burns is secretary.
All right, thank you. Welcome. I'm going to read some identifying information into the record, and then I'm going to turn it over to Mr. Freeman. Your case has been assigned to him, so he'll take the lead.
Yes, ma'am. Thank you.
Okay. So you're here this morning seeking a full pardon with restoration of firearms rights. You were sentenced in Royals Parish in December 2003. 18 months, Department of Corrections, 3 years that was suspended. You were placed on 3 years supervised probation, which you successfully completed. The conviction was for indecent behavior with a juvenile.
Right.
Okay. Mr. Frank.
Okay, Mr. Juno, first, tell me, what did you do to get you to put you on supervision and
I was tutoring and I asked someone for some pictures, and that's how it all started. I went to get them results and everything. They called the cops, and the cops came. That's how it all started. Ever since then, I've been working hearings and everything.
what do you do now, Mr. Juno?
Now it's like volunteer stuff, you know, like the church, veterans, things like that, charity.
Okay. What's your job?
I'm looking for a job. Yesterday I stopped and asked the farmer for a job, and he said they're not quite ready yet to start harvesting.
Correct.
But when they do, he's gonna call me.
All right, and I see you. Okay, so I do want to know for the record that the victims are opposed, and you have lots and lots of law enforcement opposition. Assure me, try to tell me something that would make me feel this isn't going to happen again.
Oh, I done learned my lesson. It's never happened since, and it's not going to either. I mean, I just stay to myself, my family, and that's it, you know.
Okay, and how old were you when this happened?
29, 30.
And how old are you now?
54.
Okay, I have no further questions.
Any questions?
Well, we'll let the attorney close it out. He's ready.
Well, I just noticed that the pictures were of young girls.
Yes, ma'am.
And then also that you were in a a trusted position in your life. You were
Yes, ma'am.
a church member and a tutor. And so the pictures were they were explicit. So that's what got you in trouble,
Yes,
not just pictures. I did want to point that out, that they were explicit of young girls.
Yes, ma'am.
I wanted to make sure that I got that. Thank you.
Yes, ma'am.
And just for the record indicates there was also a subsequent conviction related to sex offender registration that was reduced. Can you speak to that for us?
I'm sorry, ma'am.
There was a subsequent conviction related to sex offender registration that was reduced. Can you just speak to that for us, please?
Okay.
What happened with it?
That, okay. I'm sorry.
Thank you. That's okay.
Forgive me. I must have forgotten to sign in or something at the time. I'm not sure.
Okay. I don't see any other questions. So, Mr. Burns, would you tell us what you'd like us to know?
I'd actually like Mr. Juno to clarify his answer to one of your questions.
Okay, sure. Yes.
Okay. And that failure to sign in one time, is that a one-time thing? Or did
Yes, sir. Yes, sir.
But you did get convicted. You pled to it.
Yes, sir, I get.
Okay.
I just couldn't find my receipt.
First of all, he was younger. This occurred. He is older. Human beings go through a life. He was caught, convicted, and punished for what happened. These urges, I'm 60-something, these urges go away more as you get older to a certain extent. He hasn't had problems since. He said to you that he did make a mistake. He hasn't repeated that mistake. I do also want to speak to one aspect of his request. He's asking for a pardon. He's been before this pardon board before, and he was not granted the last time he was here, but he was strongly encouraged to apply again, and he's done so. There's one other thing, and this is certainly not something carved in stone, but he is asking for restoration of the firearms. He's talked with me about how he likes to hunt. That's what he's looking for. He wants to be able to hunt again. I do know that our current president and our current Supreme Court is interpreting the Second Amendment in a much stronger way than it has in the past. So I don't know if that would have any weight with this board or not. That's sort of the direction the country is heading. So if that has any effect, I appreciate the board taking it.
I'm just asking for a chance. I won't let you down.
Thank you.
I make a motion for an executive session.
Second. We have a motion by Mr. Freeman, second by Mrs. Stapleton, for an executive session to discuss confidential matters. Would you call the roll, please?
Vanessa,
Yes.
Stapleton,
Yes.
Prater,
Yes.
Tillis,
Yes.
Reed.
Yes.
All right, so we'll be in executive session for a few moments. We'll be right back.
Well, this one's kind of an interesting angle, isn't it? The old, yeah, I had inappropriate pictures, but I want my gun back. And those of you who have hung around here know I'm very much a 2A absolutist, from a standpoint of don't tell me how many I can have or what kind I can have or anything like that. But I do believe that your constitutional rights can be forfeited by your actions. So I would lean towards no on this one. But we're a couple minutes in the Wayback Machine, so let me bump past this executive session and let's see how it finishes up. Here we go.
Without objection, we are back in regular session at 9:11. Mr. Freeman.
Okay, Mr. Juno, after much consideration and looking at everything, I'm still just a little worried due to the ages of the victims. And due to law enforcement and victim opposition, my vote is to deny.
Mr. Prater.
Ma'am, my video is disabled right now.
Oh, I'm sorry. We're having a hard time. Can you turn it up?
Okay, now, thank you. I concur with Mr. Freeman. I just, a serious offense like this that is so prone to be repeatable, my vote is to deny this.
Mr. Tillis.
Due to law enforcement opposition, my vote's going to be to deny.
And Mrs. Stapleton.
I agree with Mr. Prater and Mr. Tillis. It involved a serious crime, child sexual abuse material, and it is prone to be repeatable when you're in, especially in a trusted position, which is where you were. You were in charge and you were a tutor for these two girls. And so as law enforcement opposition and the age of the victims, and the serious nature of the crime, my vote today is to deny.
All right, Mr. Juno, despite the age of the conviction, I do know you successfully completed your supervision and registration. I think the underlying facts involving the exploitation of juvenile victims is concerning, and there's continuing opposition from law enforcement. So my vote today is also to deny your application today. Back to you, sir.
All righty, denied. I personally am not surprised one bit by that one. Let's do this. Let's go to Texas. We will say good morning to Judge West.
Good morning.
Good morning.
Good morning. Are you Edward Godfrey III?
No.
And Mr. Godfrey was previously here in cause number 26 DCCR 0383. Entered a plea of guilty to assault family violence by impeding breath or circulation. I've received the pre-sentence report. Have you both had an opportunity to review that report?
Yes, ma'am. Yes.
I'm sorry.
Yes, Your Honor.
Are there any additions or corrections?
None more, Judge. Not so.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 6 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. This is such an excellent opportunity for you. You're very young. You do not want a felony conviction on your record. It'll change your life in a very negative way, in lots of ways. You can't go to obviously certain jobs, schools, apartments, it just all kinds of things. And so part of your probation is going to be that you get your GED or finish school, one or the other. So if you're not going to go back to school, then you have to start that GED process within 30 days of today. That's not just for me, that's for you. That'll make it also everything in your life easier, getting better jobs and things like that. It's very important. It should be important to you. So I want you to get that done. You're going to go through some classes. You're going to do everything you're supposed to. Then at the end of your probation period, if you're successful, the case is actually dismissed. You never have a felony conviction. The other side of that, though, is if you do violate any condition of probation, you can be brought back into court, found guilty. So you would be a convicted felon and you could go to prison for up to 10 years. Do you understand? You understand? And also, it is a condition of your probation that you have absolutely no contact, communication in any way with Ramsey Howard. Do you understand? Okay. All right. I'm handing you the trial court certification that shows this was an agreement that I followed. And so you've waived your right to appeal. All right. Good luck to you. You can go back with the bailiff. Marvin Watts, Mr. Parker.
Good morning, Your Honor.
Good morning.
Mr. Parker.
Do I have,
He signed on your spot on one of, wait, I'm just fixing it.
both cases or just one?
Just one.
He's putting on both cases. He signed.
He just signed one spot.
Oh, because I don't see any here yet.
Yes.
Okay.
Listen.
And sir, are you Marvin Lee Watts
Julie.
Jr.? And Mr. Parker, will your client waive the formal reading of the indictment in each case?
That's Your Honor.
Mr. Watson, cause number 25, DCCR 1918. You're charged with the first-degree felony offense of aggravated robbery from October 2nd of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? And then in clause number 26, DCCR 0946, you're also charged with a first-degree felony offense of aggravated robbery. This is from September 12th of 2025. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And because you did what they charged you with. In each of those cases, I have here on the tablets documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand if I follow the agreements that you've made with the district attorney's office that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached in each of your cases is for a cap of 17 years in prison, which means you're leaving your punishment up to me. I can give you 17 years. I can give you less. It'll all depend on the information that's brought to me at a sentencing hearing. You have every right to have a jury come in and decide 2 things. First, to decide if you're guilty or not. And then if they find you guilty, you could leave your punishment up to that jury. If we go forward this way, you're waiving that. And is that what you want to do? So you have, what you've agreed to is a cap of 17 years, which means a cap, all that means is that you're leaving your punishment up to me. And you could, if you wanted, have a jury decide instead of me. But if we go forward this way with the papers that you've signed that says that you're waiving a jury and that you want me to sentence you within that range of punishment, which would be between 5 years up to 17, there's the possibility of probation. It'll all, again, depend on what information I get when we come back for sentencing. And is that what you want to do? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
Objection.
It's admitted in each case. Is there any evidence that Mr. Watts is not competent?
Negative.
All right, sir. In each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence to find you guilty. However, I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your cases for when we come back for sentencing. Anything that you think is important for me to know, make sure you get that information to Mr. Parker. He'll present it to me on your behalf. And we can.
Yes.
Right. You can go back with the baby.
Thank you, Judge. Thanks for getting me in.
Yes, sir.
Thank you, Your Honor.
Mr. Macon, you have Cyprian Avedontu. Yeah, it's not even close, I'm sure, but Avedonute.
Romania.
What's his name, Judge?
Cyprian Avedonite.
We got
You didn't want to relay that?
Okay.
Good morning. Good morning.
How you doing?
Welcome. That's I just realized now that I'm reading them, I'm noticing that they're backwards. Did you? What's that? No, they changed it and she's getting it changed back. Yeah. Good morning.
Good morning.
And are you Cyprian? Is it Avedonitue?
Yes.
Close enough. All right. And Mr. Avedonitue, I can't say it, is charged with unlawful interception or use of a wire oral electronic communication. And Mr. Macon, what is the announcement?
Yeah, and I'm going to call him Cyprian. Just got back here from California. He was in custody out there and they brought him back. And Pam was just appointed on the case. And I really haven't got with her to discuss all the things. Plus, I have a Romanian interpreter interpreting quite a few papers that show my client was out of the country. But I would ask for a normal resetting.
Okay.
I'd work on all that.
All right. And Ms. French, any issues with the
No,
reset?
I've been given a thumb drive with information on it and I'll be reviewing that as well. So I appreciate the reset.
All right, we'll just do a normal reset and then we'll see where we get the next court date. You can go back with the bailiff. Mr. Kelly, you've got Dalton Batiste.
Judge, that's Mr. Coleman's hold on to that case. Can you hold it just for a minute? He knows Mr. Kelly's here.
Sure.
He's gonna come up with it.
Thank you.
Thanks. Not yet, I'm sorry.
Not at all. Thank you very much. Thank you very much.
See, Mr. Lewis, you've got DeJuan Banks.
Yes, ma'am.
DeJuan Banks.
Right. No. They just
Morning. How are you, Mr. Lewis?
I'm doing all right. That's fine.
Good. Good morning. Are you DeJuan Banks?
Yes.
And Mr. Banks, in cause number 25 DCCR 0990 is charged with injury to a child, elderly, or disabled individual. What is the announcement?
Well, Judge, when last setting he was here, I think it was some issues where the state was trying to locate what placement where the child was, so we can try to move this case along. We have since found that information out recently. He is out of state. So I know now they're
Judge, if it makes sense to you, Mr. Lewis has been nothing but helpful to me. And we have talked about different offers that one would expect would resolve the case if guilt was really on Mr. Batiste. What I'm trying to do is find
Banks.
Sorry, I'm sorry. I'm 30 seconds behind. Sorry about that. If that makes sense what I'm saying without saying it out loud. The child is in the custody of family members under the care of foster care. So when I look from everything I have access to, it looks as if the child is in the care of foster care, which is where I have been going to try to locate and put people to speak with. But now the child is in foster care, but with the family, if that makes sense. And I wouldn't know this information but for Mr. Lewis, which is now who I need to speak with. I know it says final. If we need to put it on the trial market, obviously that will be done well in advance of when that trial market would be. That's
No, I guess
just
you're
an
saying
issue.
you now have, where you.
Yes.
Okay.
Even though all the logistics say foster care, the child is still in foster care, but is with the grandparent.
I'm going to do one more reset to give you some time to get a visit with them, and then let's get an announcement at the next.
And they have been generous with that information. Otherwise, I wouldn't know where that child is other than through the foster care system. And he's not a possessor of custody.
Okay. All right. Thank you. You can go back with the bailiff. Thelma Gilbert.
Gilbert.
Good morning. Are you Thelma Gilbert? Answer out loud, please. And this is clause numbers 26 DCCR 0502, 03, 04, 05, 06, 07, and 08. Ms. Gilbert is charged with credit or debit card abuse in 4 of those cases, burglary of a habitation in a case, fraudulent use or possession of identifying information, as well as theft of property. And what is the announcement?
Judge, we've gotten a offer that will probably resolve this matter. It's going to involve a lengthy prison sentence. Our issue right now is day before yesterday, Miss Gilbert's daughter and her father were involved in an auto accident, and they're being hospitalized in Dallas. So we're trying to find out the status of exactly what's going on with them. So she'll know basically the stability of a daughter before we do the agreement. So I'm just asking for a short setting so we can get that resolved so we can move this case along, Judge.
I told Mr. Lewis I would hold that offer open if we got to reset for that reason at 89.
All right, I'll reset it one time for that.
Thank you, Judge.
You can go back with the bailiff. Thank you. Pham, Mr. Lewis?
Hold on that one.
Sure. Thank you. We'll hold that.
Hold on.
Alrighty, friends, halfway through TCF Live on this Tuesday. We will keep an eye on Judge West, of course, but let's go across the hallway, checking with Judge Stevens.
Okay, looks like on June 23rd, a motion to increase the defendant's bond was filed by the state, correct? That's what I've got in here from Ms. Gonzalez. You're not, are you?
From my understanding, Judge, last time I saw that the defendant was in court, there was some information revealed about contact with the victim. And so Ms. Gonzalez may have filed a motion to increase his bond based on his contact with the victim.
Hereby alleges defendants violated conditions of bond, specifically not having communication directly or indirectly with the complainant victim of the pending case, nor going near any residence, school, job site, or other location. State has reason to believe the defendant has violated these conditions. He appeared with counsel in front of the court on June 16th and stated he had not had any contact with him. On the same day, the victim's mother called the district attorney to report he has in fact made repeated communications to her and her daughter, the victim, and stated he would take them to court to get custody if he was not allowed to see his daughter, the victim. The state contacted the victim's mother again on June 23rd and was informed he has been to the house where victim and her mother lived multiple times and told them that he did not have a bond condition where he was not allowed to speak with them. Additionally, the victim's mother states he has called her multiple times wanting to see his daughter, the victim. Whereas state praise that the bond amount be increased. That's what they're asking for.
Your Honor, if I may, in discussing with Mr. Rodriguez, he wants to obviously comply with all the conditions that are required of him.
It's not that he wants to. Well, he doesn't have a choice to, or else he goes to jail.
What I mean is he's not intentionally violating a court's order. If I may, Your Honor, when he was arraigned by Judge DeRuin, these were the conditions and terms of the order that the court will notice. These boxes were not checked. when he was arraigned by Judge Buchanan.
Hold on.
You have that in here. This is what I'm referring to.
See what's in the court file.
No,
It was only built by him.
the two boxes that aren't checked.
Wait, what does state know about this? You just kind of picked it up, didn't you?
Yes, sir. I did speak with Ms. Gonzalez before she left, so I knew that the victim had made a call to our office letting us know. And based on the documentation that defense counsel has, it says no communication in a threatening or harassing manner. And based on the report from the victim, his communication was in a threatening or harassing manner.
While we're waiting on Judge to page through all that paperwork.
He has been served with a protective order on June 25th.
Don't interrupt me. Reminder tonight, sidebar, right here on this channel, 8 p.m. Eastern, 5 p.m. Pacific. We're going to base the discussion on a couple of cases where the parent of some children in each case was accused of neglect. So do join us for that right here on this channel.
He didn't have any notice of it. Now I can elicit that from him under oath, Your Honor. Under penalty of perjury.
Yeah, go ahead.
You
I want to know.
Swear?
Yeah, raise your right hand. Do you solemnly swear or affirm any statement you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Lower your hand. Go ahead. Give it your best shot.
Well,
go ahead.
As far as
go ahead. Ask him the
the
question.
protective order that the court has indicated that it was entered on December, what was the date, Your Honor? December 16th? 15th?
Stand by. 15th.
15th. Were you served with that, or did you sign anything indicating you had received it? Did you know about it?
No, sir. The other thing that I got served on was the child support, and this one that I just got served last week.
And you say this one you're pointing to the
one that I got a hearing for this week on the 9th.
July 9th and the 3/17th. Is that correct? I think that's. I'm sure it calls me on here. That's clause number 26, DCF M 0782, the detective ones.
Yes, sir.
And you were served that on July 9th. I'm sorry, June 25th. Is that correct?
Last week.
And that's set for hearing July 9th. When you were magistrated, given your magisterial warnings by Judge Buchanan back on, what was the date of that? March 12th of 2026. Were you advised that you could communicate with a person protected by the order or a member of the family, that you could communicate with them as long as the communication was not a threat?
Correct. I personally asked him and he
Threatening or harassing manner, is that right?
Yes, sir. I personally asked him again after he gave me the paperwork and he said that I was able to see my little girl.
Just the reigning magistrate.
Yes, sir. I don't know his name, but yeah.
Okay. Now, when you bonded out, did the bondsman present you with paperwork that indicated you were to have no contact?
They did, and I brought this to their awareness. And
you
they
say this, you mean the order signed by Judge Duran?
Yes, sir. I brought that to their awareness, and they said that they were going off of what he said.
What the magistrate, what the judge had said, not what you were saying. Is that right?
Correct.
The bondsman. And based upon that understanding, did you have? I mean, you had communications with them, with him.
My little girl.
Okay. You had communications with her.
Yes, sir.
What about the alleged victim, your wife?
Well, that's how I was getting in contact through her. And whenever child support, I had a hearing with them. They said that they're going to wait for your date of court to come in order for them to give me the rules on what they agreed to. They said they were going to go with what Judge Stevens says.
You talking about CPS or child support?
The child support. So I have a court with them this month as well too. They wanted to see what Judge Stevens was going to say.
Well, we were in court in front of the judge. Judge Stevens personally told you not to have any contact. Is that right?
Okay.
What date do you recall the date?
I think it was the 16th of this month that just passed.
June.
Correct.
June 16th. Since June 16th, have you abided by the court's directive to you not to have any contact?
Haven't had no contact with them ever since.
My passwords.
I have no questions for this witness, Judge.
So let me see your driver's license, please.
Your Honor, obtaining a court, defendant's driver's license.
Thank you. What we got here is just some confusion. Here's the magistrate's order for the emergency protection that was ordered by Judge Buchanan on December 16th, 2025. You never got a copy of this?
That's my copy right here.
You never.
I got it out of order.
Actually, did you sign this document that states you understand what your obligations were? Yeah, there you go. That's your signature.
This is same, yeah.
It's in blue ink. So you acknowledged on some date, this generally states signed December 16th, but maybe 25, maybe you did or did not on that date, but nonetheless, you signed this order acknowledging receipt of this order, and in this order, it states the court hereby orders you to refrain not to do the following things. You shall not commit family violence against a person protected in this order. Communicating directly with a person protected by this order or a member of the family protected by this order in a threatening or harassing manner. Communicating a threat to any person to a person protected by this order. Going within 100 yards of the residence or place of employment of the business of the person protected by this order. the person's protected by this order, or Marissa Cruz, who was yeah, are y'all still married?
No, sir.
Y'all been, when were you divorced?
We never were married, Your Honor.
You weren't even common law married?
Common law is if you live together a certain amount of time.
And hold yourself out as married.
Yes, sir. Yes, Your Honor.
And then Rosaura Rodriguez is your daughter. Okay, those are the two people who are protected by this order. So what changed subsequent to this? Because this order is in effect and by the judge. And
I think it expired in March, Your Honor, if you look at the paperwork. There's an expiration. I was perusing it. I noticed that I believe it's expired in March 12th or something. It's in there.
I don't see these every day.
You see that?
Okay. Is effective until midnight on March, I guess that's 12/26.
Right.
So after that, are we here on things subsequent to that date?
And then, Your Honor, he was served on June 25th with the protective order of family. So now there's this order's in effect. June 25th.
Well, I don't think I have.
That's not clear, Judge, as far as whether or not we're here on things that happened before or after that.
What are we
March
here
date.
on then? I think the state has a motion to increase the defendant's bond that was filed on June 23rd. And it states that the defendant had not had any contact. This is on June 16th. That the defendant had not had any, stated he had not had any contact or communication with the victim. On that same day, the victim's mother called the district attorney's office to report he had in fact made repeated communication to her and her daughter and stated he would take them to court to get custody if he was not allowed to see his daughter.
Not for me. I think June 16th we were in court and the court verbally admonished him not to have any contact. So we could go from the 16th.
This state contacted the victim's mother again on June 23rd and was informed that he has been to the house where the victim and her mother lived multiple times and told them he did not have a bond condition where he was not allowed to speak with him. Additionally, the victim's mother stated he has called her multiple times wanting to see his daughter. And then that's the state prays for the granting of a motion to increase the defendant's bond. All right. The problem with this is, because I don't know what the times, dates, or events are. It's just generic. And so the court really doesn't have any, in the four corners, it's not specific enough, but it does generally allege allegations of wrongdoing, which need to be supported by more evidence than what the four corners state. But the point is what are the orders? And we're going to, the whatever the orders are that are in effect and might be superseded by other orders. What orders are in effect, but from we got different orders running around from at least 3 different courts now. So mine are important to me, and the ones I give are to be followed. And if he fails to follow after the court's rendition and order goes into effect, then he's subject to.
Obviously, since June 16th and the court's oral admonishment to him and we did not have any contact, he's invited by then.
Right. So what can the state say about?
Judge, I just want to be clear. So I know that paper had no contact in a threatening or harassing manner. Is the court ordering him not to have any contact with the victim or the victim's mom at all?
Yeah. Okay.
That was my understanding.
Yes. Yes. Okay. I want everything frozen.
Okay.
Until we can resolve this thing as soon as possible. But then what happens is is typically is that everybody's got a different story about what the facts are when we're not watching, and then the court's got to resolve the dispute. But the orders, we've got 3 sets of orders here about freezing the action and not having any contact. And
Well, 4 if you count the Boston.
And I don't have to remind you about what the 4 corners of the indictment state. These are very disturbing allegations. So I'm a parent, I'm a grandparent. I can't even fathom even thinking about what these allegations state. I mean, they're very disturbing if they're true. But the grand jury found enough evidence to bring an indictment. So we're going to make sure that whatever evidence they had to support their rendering of an indictment, that is enough for us to freeze the action. And until we can resolve this, I don't want you having any contact, because whatever you do can be, unless we have a jury watching you, it's he said, she said. And I get frustrated with that because that's hard to resolve. But what is easy to order is no contact, nor anyone on your behalf. And get whatever orders we need to be placed in this case until this case can get tried, need to be done. So we've got a family unit that's obviously not a unit, which I know I want a family if it can be put together. If not, then the law will dictate how that will happen. But these are very disturbing allegations. How old is the child, please?
She's turning 2 on September the 27th.
She's going to be 2 years of age?
Correct.
All right, what's the state asking for? Any other relief?
No, sir. We'll refile the motion if needed with better dates. If not, we'll just continue on to the disposition of the case.
Okay, so the orders are you can't have any contact with the child or the mother unless otherwise ordered by the court.
Absolutely.
Your Honor, to be clear, that's direct or through other people. You can't get other people to contact them.
I'm sorry.
It's direct and indirect. You can't get other people to contact them on his behalf.
Yeah, you think
Just to be
yeah, acting on your behalf is the same unless it's otherwise approved by the court. Trying to think we're missing something. I don't want something bad to happen here because we had a loose end. Anything else anybody can think about?
Nothing more from
Do
the
we need
state
a
judge.
GPS device or something on it so we know where he is?
I'll defer to the court, Your Honor.
I would suggest that based on the circumstances surrounding the initial case, Judge, I would suggest that. And the fact that when he was asked about the contact, when he appeared in court the last time, he said no, when there was in fact some contact at some point in time.
Can you explain that?
I think, well,
Can you explain that?
Well, Your Honor, I was.
Why weren't you forthright with me?
No, I was asked if I was living with him, and I said no, I wasn't living with him. And I was basically going off of the other paper that I received from whenever I got out of the county. But ever since you mentioned that, no contact. And on my work of mine too, I do go see people on a daily basis, and I don't know that monitor. I mean, shorts. I don't know if that's going to be looking real presentable on my end.
You know what? I couldn't care less.
I understand.
That's not my concern. You put yourself in the situation.
I understand.
Okay. Well, you're going to have to, it's not going to be as convenient as it would have otherwise been. had we not been in this situation with these allegations.
Correct.
But yeah, that's if I order a GPS, then that's your problem. You have to deal with it. We got a lot of people running around GPS in this court, out of this court, and they function. But once again, those are problems that occur that have to be dealt with, that the court has to respond to ensure that the status quo is kept until we can resolve this. If I find out about it, I don't think and one other thing that bothers me is what they're saying is in this probable cause affidavit, this occurred while you were apparently intoxicated. What about that?
I shouldn't drink or consume intoxicating substances as well, Your Honor. No alcohol.
Yeah. Obviously, that may have, which is not an excuse under the law, but I see it all the time. And people, well, I was intoxicated. Unless somebody forced it down your throat, you are responsible for your actions. All right, what's the next event?
He had refused the plea. It's a straight probation officer. We had wanted deferred, so I've set it on the trial document, I guess. I'm not sure at this stage that the plea had unagreed. I mean, I'd like him, if I'm going to do that, to establish a track record on his part that he can abide by the court's conditions while on bond. So in order to have a better argument, if I do go unagreed to the court, that you should give him deferred instead of straight or a state's injection. That's where I am with it.
Mm-hmm.
He doesn't have any criminal history. No, he has significant criminal history. He's eligible for jury probation, but of course that would be with a conviction. But the state's not offering deferred at this point.
What's up, man? You need anything, man? Hey, I told you.
Said if I am going to go to the court and ask for deferred, I'd like him to have a track record. He can abide by these conditions and do what's required of him. For the court to consider that, making its determination of whether he should get deferred or not.
And just to correct.
Here's the go ahead.
I'm sorry.
Just to correct for the court, defense counsel just made a statement that he doesn't have any criminal history.
Significant criminal
Okay,
history.
he does have a couple possession of controlled substance and I believe an unlawful carrying of a weapon.
No felony. That's a significant criminal history, Mr. Call.
Just aside here, why don't y'all look legally at the indictment, what it states. Is under this indictment, is he eligible for regular probation in front of a jury? I don't think so, because it says a firearm was used in the commission of the crime.
So the jury can probation.
I think so.
On 3G, I thought they could. I'll have to review that.
I think that needs to get looked at.
Yeah, that changes the perspective if that's the issue.
All right,
I still would like to have him out for a while. I'm going to go to the court.
Sorry?
I would like him to be out on bond to establish that we can abide by the court's conditions with one attempt to get the court to get him deferred.
What else do we have to, what orders are you asking right now in this court?
The GPS, the no alcohol or drugs, and the no contact.
I don't see that that's unreasonable. I'm going to order that. You got 24 hours to get all that done. Go through him. He knows how to do it. But two of those are things that are going to be your decisions in your actions. The other, you have to have a GPS device so that if there is ever an issue, yeah, I wasn't there. Yes, I was. No, yes, he was. No, he wasn't. And the GPS will monitor your whereabouts. And again, no contact with the mother or the child until further orders. Anything else set? And our next event is what, trial? Is that what you want?
Well, just set for that, this one.
Sir.
Just got set for now.
All right, how long?
I think it's.
What do you want,
most
4,
likely
6 weeks?
6 weeks, that's fine.
6 weeks. Thank you. Okay, that is all. Please get resetting. Thank you. Braden.
Alrighty, friends, we'll probably come back to Judge Stevens, but let's change it up a little bit because we've been there for a while. Let's go to Newaygo County, Michigan, Judge Springstead. Say good morning to him.
This is our final status conference in this case. It is set for the trial starting August 3rd. Is there a final offer that the people are making?
Yes, Your Honor. After extensive communications with the defense in this case, as well as the family of the deceased, people have decided to make an amended offer that the defendant would enter a plea to the moving violation causing death under MCL 257.601D, parent 1, with the moving violation being failing to stop at a stop sign in violation of MCL 257.671. And the agreement with that is that the defendant will serve a year of jail as a sentence for that crime. And in exchange, the people will dismiss the currently charged OWI causing death.
All right, and Mr. LaPrey, is that your understanding of the offer in this case?
It is, and in addition to that, if you recall, we had an in-chambers conference the last time we were here in court back in June, and we had discussed with the court the possibility of my client serving jail time in Muskegon County where she lives and having a work release order. The court was in agreement with that. I have made contact with the Muskegon County jail as well as the Newaygo County jail. Lieutenant Cook from the Newaygo County Jail had a conversation yesterday with the captain, jail administrator in Muskegon, and they have agreed that my client could serve the jail the 1 year in the Muskegon County Jail with a work release as long as the order at sentencing states Muskegon County Jail and with a work release order. As long as she follows the rules with the work release, then they would allow that. If she were to break the rules, and they would send her back to Newaygo County. Where she'd be lodged in the jail here. So all those arrangements have been made.
All right, and it sounds like she wants to enter a plea.
She does.
Is that correct, Ms. Carey?
Yes, sir.
Raise your right hand, please. You solemnly swear oath to affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth so help you God.
Yes, sir.
All right, and Ms. Robinson, do you have updated charging documents?
I don't, Your Honor, have that, but I do have the language with the correct inserts, if I may approach the court with that.
All right. The charge that you're entering a plea to read as follows: that on or about May 24th, 2024, that you were in Sherman Township, Newaygo County, State of Michigan, and that you committed the crime of moving violation causing death. That you did commit a moving violation to it, failing to stop at a stop sign, contrary to MCL 257.671. That was the proximate cause of the death of Alexander James Barber while operating a motor vehicle upon a highway south Barber. This is a misdemeanor which carries up to 1 year in jail and or $2,000 fine plus cost. You understand the charge and the maximum penalty?
Yes, sir.
All right, and you have an agreement in this case that you'd be sentenced to 1 year in the county jail. You understand that?
Yes, sir.
That 1 year in the county jail can be served in the Muskegon County Jail through their work release program, provided that you pay any fees or assessments, that you follow all their rules and regulations, and as long as you do that, you can serve it on a work release. If you violate, you're going to come back and you're going to serve your time here. Do you understand that?
Yes, sir.
Right. Is that your complete understanding of the plea agreement?
Yes.
Have you had sufficient time to consult with Mr. LaPrey about your original charge, this amended charge, and this plea agreement?
Yes.
And subject to the plea agreement, how do you wish to plead? You understand that if your guilty plea is accepted, you'd be giving up your right to have a trial of any kind.
Correct. Yes, sir.
You also understand that you're giving up the rights that you would have at a trial. Did you receive a copy of the basically, we have a felony plea sheet? Do you have one of those? I should be one on the counter. Should be one on the desk.
I have advice of rights.
Yeah, and advice of rights. Yeah.
Yes, sir.
All right. Did you read that document?
Yes.
Did you understand those rights?
Yes.
You signed it?
Yep.
And certainly you've been over those trial rights with Mr. LaPrey before today. Is that correct?
Correct.
Has anyone threatened you to get you to make this plea?
No.
Has anyone promised you an outcome different than we put on the record?
No, sir.
Are you entering this plea of your own free will?
Yes.
Understand that if I accept your guilty plea, you're giving up the right to later claim that this plea was not your choice.
Yes, sir.
You understand that if that I'm not bound by this plea agreement, but if I don't go along with it, you can withdraw your plea.
Yes, sir.
You now give up your right to have a trial of any kind, and all the rights you would have at that trial, and do you still want to plead guilty?
Yes, sir.
Is it true then that on or about May 24, 2024, that you were in Sherman Township, Nuevo County, state of Michigan?
Yes, sir.
You were operating a motor vehicle on South Baldwin Road?
Yes, sir.
Did you commit a moving violation?
Yes, sir.
Tell me what you did there.
I blew the stop sign, hit another vehicle, causing that person to die.
Okay. So you failed to stop at a stop sign and you hit another vehicle while operating your vehicle, and that individual, Mr. Barber, is that correct?
Yes, sir.
Are the attorneys aware of any promises, threats, or inducements which have not been stated on the record?
No, Your Honor.
No, sir.
Is she competent to enter this plea?
As far as the people are aware, Your Honor.
She is.
As the court complied with MCR 61302 and the plea for taking, and the rules for taking a misdemeanor plea.
Court has, Your Honor.
Court has, Your Honor.
The court does find the plea to be knowing, understanding, voluntary, and accurate. Do the parties wish to proceed to sentencing today?
No, Your Honor. We'd ask that there be a sentencing date so that the victims may be present if they would like to speak.
Okay. How much time would you like to arrange for that? I've got next week, July 14th at 10:10. Otherwise, my next available date would look to be into August.
Your Honor, I'm in a trial next week that is about 4 years in the making. So if we could do it maybe into August, I would appreciate that.
Ms. Miller, do we have anything before August 25th? Those dates, I contemplated having a PSI. I don't think we need a PSI in this case, do we?
No.
We have August 10th at 3:10.
I got final Solomon conferences in Muskegon and afternoon.
August 11th at 10:10.
Yes, I can do that.
So we'll set it for August 11th at 10:10.
Thank you, Mark.
All right, so Ms. Carey, that'll be your sentencing date, and if everything goes accordingly, you should be prepared to begin serving your jail sentence that day. Okay? All right. That's all for today.
Alrighty, Ashley, could you do us a favor and make a note August 11th, 10:10 with Judge Springstead, and let's see if we're able to catch the sentencing at that time. Julie says since she will not be charged with homicide itself, a civil case might be iffy as well. Different burden of proof there. It's more of a preponderance of the evidence, so we'll see on that. Thank you, Ashley. And I gotta say, I want to do a little research on this case. My spidey senses are going off here a little bit. Something is amiss with the state's evidence. For them to drop the whole OWI part of this. I don't think that their proof was solid on that. I could be wrong, but that's just what my gut is telling me. Time will tell, I guess. Let's go back to Texas, Judge Stevens.
Looking at no less than 2 nor more than 10 years confinement in prison, and the fine up to $10,000 can be assessed. Do you understand the punishment range that is applicable if found guilty here?
Yes, sir, Your Honor.
It's the last one. New possession of substance. And she got arrested last night, so she's currently with Dutch. They're really beginning.
What's the relationship with the complainant here and the defendant?
As of right now,
What's the relationship? Langston? What is there?
Oh,
Was a police officer.
it's a police officer. This is
Harassment of a public
harassment in
servant.
the service. It's the
It
police.
says the complainant additionally advised that
The lady,
was attempting to force entry into her residence by kicking the door in.
she's not complaining at all. I think police officer saying he was spit.
Upon arrival, officers observed the complainant, Caden Branch, and Charlo in the front door. I mean, this probable cause talks about a complainant.
Right, but
Branch said that Charlo pulled a knife on her and wanted him removed for her property.
Right, but
then officers were investigating, and he becomes uncooperative and begins to walk backwards. Officers grabbed a hold of him. He began to physically arrest. Then he was handcuffed and let's see, turned in the direction of officer and spat on her. While a search was going to be conducted in front of the police vehicle, he caused someone he knew to be a public servant to come in contact with saliva while the public servant was lawfully discharging an official duty. Also, apparently the defendant grabbed Caden Branch by the shirt and tried to kill her while having a knife in his hand. Branch advised that he had left the residence, but he returned shortly after, and that's when he kicked the door in and police were contacted. Branch wanted to pursue criminal charges. Charlo was placed under arrest for assault, family violence with deadly weapon, and harassment of a public servant.
Judge, I'm not sure why I don't have the ag assault case. I only have the harassment of a public servant.
I'm over here for the harassment. Okay. Today, what is this for today?
This is our first sitting, Judge. We want to put it on the announcement.
Okay. Couple of things. Orders are going to be entered to have no contact, nor anyone on your behalf contact the complainant, who is the officer, nor the person Miss Branch, the person that the police came out to investigate you and your bizarre behavior that day. And you're going to have a GPS device, so I know where you are. So if you get any contact with her, I'll know about it and place you in jail. And that's where you will stay.
Can I say something, Your
Go ahead.
Me and her are actually still friends. She
No. Friends don't act this way.
No, like we kind of like stayed together.
I don't care. Friends don't act this way. She called the police.
Yeah, she dropped the charge.
I don't care. She called the police.
Yeah,
you, unless she lied to the police, and then we'll bring her up here. And then that's a crime. I want to know. She apparently was not lying when you acted the way you did this night, not only spitting on the officer, but pulling a knife on your friend and attempting to force entry into her residence by kicking the door in. Don't have any contact. She's going to be a witness in this case. That supersedes any
even if she
attempt to try to change her story.
I was in a county on both the charges.
I don't care. You're under my jurisdiction right now.
Yes,
you're going to follow the rules and not act foolish. You're going to have a GPS device so I know where you are. Have no contact with this witness and no contact with the officer as well. Do you understand? That's a yes? Okay, nodding doesn't get it on the record. You have to speak. That's the way we communicate. You understand?
Yes, sir.
Your problem is you're not following the rules. You're looking at up to 10 years in prison. Does that bother you? Does that worry you at all?
Yes.
It should. It should. All right, what's my next event? Announcement?
Yes, sir.
You have 48 hours to get the GPS device. And those are the orders of the court. That is all. Quarterly cornish.
I started. No, here. Just take it on. We'll bring it back when you're done. But hey, let's think forward that. I'm sorry.
Is this an initial? No, it's an announcement.
This is an announcement. We did do discovery on this case.
Yeah.
And in talking, and the state's offer.
Ooh, God, dog, it's 2 years old. Almost.
Right. And we looked at police reports. Miss Cornish is informing me that she's absolutely innocent.
Yes, Your Honor.
That's what the presumption is all about. I tell you, if I could just get a case here where extreme intoxication wasn't part of the actions, I jump off a cliff, because that's what this is over and over again. Everybody's intoxicated. And here's my favorite thing. You're driving a car. Y'all are both intoxicated and in a vehicle, a 4,000-pound missile. Great. Yeah, I know you're smiling, but you know what? You know what we deal with in here? People who have been struck and killed by fatal incidents by drunk drivers. And there's no laughing. It's all a bunch of crying and sobbing and people begging to get their loved ones brought back. You ought to just sit in here and watch that. You wouldn't smile. Wrecked. So you wrecked the car, her car, and not wrecked it into any other kind of vehicle, but into a patrol unit. Inviter, which the unit was working erect, and you were obviously so inebriated you didn't know what you were doing.
Oh, you're in.
The complainant says you drove her car without permission and wished to file charges, and she got her wish. Here we are. Here's my favorite thing. I'm going to look into whether you've had any contact with this person. If you do, you'll sit it out in jail. You cannot contact a witness while this is pending. And these facts, I mean, I do this for a long time. You look too confident about all of this because you think you've already worked it out on the side. We all know that because we see it attempted all the time here. What happens is all it does is bring more charges to you. And the court's not going to allow that. I'll order the people to show up and we'll have a trial and they'll testify under oath and they can either tell the truth or they can lie and then they get better. But here, a very serious event occurred and we're lucky people weren't killed because of reckless behavior. Not only driving someone else's car unauthorized, but slamming into a police vehicle that was investigating some kind of other incident on the road. All right, we'll set this for trial. Y'all get ready. And by the way, a jury doesn't give deferred. If you're found guilty and even if you're given probation, it's a conviction for the rest of your life.
Yes, Your Honor.
Christopher Price?
Easier.
Christopher Price, what are we doing?
This is our first appearance. Initial set with him. It's the first time I did get discovery.
Okay, what are we? You're charged on state jail felony?
Yes, sir.
Oh boy. Solicitation of prostitution, that's never a good one. It carries with it up to 2 years in the state jail. I don't see a prior conviction here. A prior conviction. You've never been convicted before. Fix this.
Yes, sir.
Hey, work with him. Who knows? What are we going to do today?
Just the plan is I was going to send a letter to Mr. Canard asking for pretrial diversion and see what he says. And in the meantime, just put it on my notes.
Okay, I'm sending an announcement. Okay. Mario, just getting resetting it. Mario Senegal.
The Senegal?
Senegal.
She's here.
State. Okay. That's you, Miss Senegal. Come on up.
Same thing with her, Judge. This is.
I don't see any prior convictions here either, huh?
Correct. And this
You've
is
never been convicted before? Okay. Fix this, fix it.
I can ask for the same thing for her. And this is her first setting before you as well.
Again, like the man before you, you're charged with a state jail felony, which carries with it up to 2 years in the state jail, but it's a felony. If you're convicted of a felony, it's with you like a horse riding on your back for the rest of your life. Closes off doors of opportunity, and it prevents you from enjoying some blessings of liberty because that conviction follows you forever. Fix it.
Yes, sir.
He knows how. All right, let's reset as well for an announcement. Ashley Stevens was reset.
Ashley Stevens is reset?
Yes.
He was arrested last night, so apparently was just run in the rain for
Sean Thomas.
He's here. I think you had set this one for a special. It was a special that you did.
Oh.
And I think I
know. He's testing positive for cocaine.
Yes, sir. I just talked to Johnny today,
And
Positive for
she
cocaine.
told me that my
Hold on.
brother-
Positive for cocaine. Positive for cocaine. Positive for cocaine 5 different times. Where are you getting it from?
So it's my barber. When my barber had cut my hair,
Say that again?
my barber, he do my hair.
Yeah.
I guess he has it on his hand.
Oh, he has it on his hands. How long you been working on that one? It's a mystical event here.
I'm sorry.
We've got the, you really think that hadn't been tried before? And if that worked, don't you think everybody would pull that one? Oh, I get it from my barber. Who is your barber that has cocaine? What's his name?
His name's Stephen.
What's his last name? You know, it's your barber. What's his name?
Stephen Giles.
Okay. So where's he getting the cocaine from if it's coming from him? Do you know?
No, sir.
Well, how do you know he's got the cocaine?
I just seen
You just first name you could think of to blame?
I see it on his hand. I seen it on his hands the last time.
How do you know that was cocaine and not other powder?
I just seen like white residue.
Oh, okay, it's powder. They use that at a barber shop.
I know I don't do it, so.
Okay, well, they use that at a barber shop. Generally, they don't use cocaine.
It's not a professional barber.
Okay, I don't care what it is. They still use powder. I mean, that's what it normally is. But hey, you chose the guy.
Yeah.
You chose the guy. Hey, you've been testing positive since. Let's see. All right. About every 2 weeks, you're testing positive. How often are you going to the barber? You're going to the barber every 2 weeks?
Yes, sir.
Yeah. Okay. Nonetheless, this is all.
I talked to Giants too the last time, and she said it might.
What's his bond right now?
You heard me, sir?
I heard you. Did you hear me?
Yes.
What's his bond? You don't run things here. You're charged with a serious crime. You're looking at 2 years in prison, and you've tested 5 times for felony offenses. You might want to stay quiet.
$20,000.
That's not enough. It's $100,000. Plus you have to have a drug patch. 24 hours. That's right. That's how we're testing it. Well, the drug patch is not working. Next positive drug, you're revoked, but you've got 100,000 now. Taken into custody until you can make that.
It's $100,000.
It's $100,000. And the next positive will be no bond. We'll work with you here to try to get you off your problem. What are we going to do next? What are we going to do next?
I guess at this point, we can put on an announcement. I can get with him to see, because I'm, now what he did tell me, and maybe this might be somewhat of help to him, is that if you look at the date of the last test, it says 5/29/26.
Yeah.
And he told, and to my understanding, is that on May the, I want to say you said 14th, on May the 14th or 15th, somewhere on there, is when he had his prior, test for being positive. And when you take this test on the 29th, that's still within that 14-day window, and the cocaine doesn't leave.
It's not, it's a 15-day wait. You just.
Well, I'm sorry.
14 29 is 15 days.
Well, 14, I'm trying to stay within. It's
I know, but that's,
within that time period.
no science has ever shown that. I mean, it's about a 2-week window.
Yes.
But nonetheless, this is spanned over how many months? 3? Come on. cocaine moves out of your system fast. We all know that. That's what it calls speed. All right,
But yeah,
those are the
we
orders of the
on-
court.
on-
That is all. Thank you. Hey, Langston, on,
Friends, that is a tale as old as time that was just told right there. You know, when I was a much younger man, my first 25 or so years of life, only one person really ever cut my hair. He was the owner-operator of Glow Barber Shop in Grand Haven, Michigan. His name was Ron Prelesnik. And I can't tell you how many times, well, Mom, you're in the chat. You can vouch for this. I'd go to the barber shop, I'd get my hair cut, and I would come home all hopped up like I just drank a 6-pack of Jolt Cola, because they didn't have Red Bull back then. We had Jolt. And Mom would just get all accusatory, like, have you been to that barber again? And I'm like, yeah. She's like, you're high on coke again, aren't you? I'm like, yeah. And then she'd like send me out to mow the lawn or something to burn it all off. But I will say, going to the barber, it's kind of a 2-for-1. You get your hair cut and you get high, and it's cheaper, quite honestly, than just buying the coke. So it makes good financial sense. I'm just saying. All right, with that story out of the way, across the hall, Judge West.
Please. All right, sir, are you Justin Thomas? And I'm going to take judicial notice of the court's files and cause numbers 25 DCCR 0308 and 25 DCCR 1874. Mr. Thomas was previously found not competent to stand trial, was sent to the John Dunn Behavioral Science Center for Competency Restoration. I've received that report dated June 16th of 2026. It includes the trial competency evaluation report, which is prepared by Dr. Guzman. The findings in that report is that he is currently competent, has achieved competency while he was there. Also in that packet is the attending physician's report to the court, and that is dated June 15th of 2026, prepared by Dr. Liberis, again with the finding that Mr. Thomas has achieved competency and is currently competent to stand trial. Is there anything else with regard to competency?
Oh, ma'am.
Then at this time, I am going to find that Mr. Thomas is competent to stand trial. My understanding is he just got back here from John Dunn, and so I'm going to do a normal reset. That'll give you some time to visit with Mr. Thomas about any options he has on his case. All right, so Mr. Thomas, Mr. Lewis will be out to see you very soon to go over everything with you, okay? All right, we can go back with the bailiff.
Thank you.
And then you've got Jason Weinberg. It's the sentencing.
That's right. Weinberg. Weinberg, Jason Weinberg.
Smart. Good morning, you're Jason Weinberg?
Yes.
And Mr. Weinberg was previously here and entered a plea of guilty in cause number 25 DCCR 1479 to the state jail felony offense of engaging in organized criminal activity. I've received that pre-sentence report. Have you both had an opportunity to review the report?
Yes, Your Honor, we have.
Any additions or corrections?
No, Judge.
Not from the state, Your Honor.
All right, Mr. Weinberg, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings. You'll be placed on probation for 5 years. You're ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation.
Yes.
If you do that, this is a great opportunity. You're very young, you don't have a felony conviction on your record, and if you successfully complete this probation, you'll never have a felony conviction. At the end, the case gets dismissed. It's a great opportunity. The other side of that, though, is if you violate any condition of probation, you can be back here in court, found guilty, so you become a convicted felon, and you could go to the state jail prison for up to 2 years. Understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. Probation will talk to you probably before you leave. Good luck to you, sir.
Thank you.
All right.
Thank you, Your Honor. Thanks.
I'm sorry. No, that was, we'll see. Since it's a state jail, she said no ISF for him. I said, no, we'll hopefully not need that. Not too bad. So, that DeMarcus Evelyn is gonna be Brittany handling that? Yes. And that's for a bond? Yes. Okay. Hi, good morning.
Can I sit home to the co-counsel? I'm just gonna take on the back. I have to do.
It is on Dalton Beach. Okay.
And congratulations.
I know, thank you.
Okay, y'all have a great day.
Thanks, you too. Let's see. I know, usually he at least stops by. Ms. Holmes, are you ready on Daniel Eli?
You may be a pro on.
Audrey's supposed to plea on, Audrey has his misdemeanor.
Oh, okay.
She's supposed to plea on the misdemeanor so that will dispose of the felony.
Okay.
I can't find Audrey.
Okay, well, I'll hold it.
Okay.
Is he supposed to do it today?
Yeah. Yes, they've always been set together.
Yeah.
It's been trying to get it all of the parties here.
Okay,
And if
I'll hold it. And
push comes to shove, Judge, I can do that today, if you allow me to put on the record, then if that does not.
that's, well, and that's fine if we need, I mean, I can just reset it a week and then get them down there this week, but
Yeah,
maybe,
it just keeps going back and forth. I think.
yeah.
Unless they let me, them, step in, if they let step in,
See if you can get, y'all already tried to call Audwin this morning.
I have not.
See if y'all can get him on the phone, and if he's around, great. If not, see if he'll give you permission to do that.
Okay.
I'll hold it for now, though.
Oh,
And then you've got Janaya Fine.
yes, sir. Please. Yeah, that's the other one. That one, she should make another copy of.
Oh, okay. Thank you.
Right.
Today's this. Good morning. Are you Janaya Fine?
Yes, ma'am. Yes, Your Honor.
And will your client waive a formal reading of the indictment in each case?
Yes, Your Honor.
Ms. Fine, in clause number 26, DCCR 0432, you're charged with a second-degree felony offense of assault on a peace officer from January 13th of 2026. And how do you plead to that charge?
I plead guilty.
Are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you did what they charged you with?
Yes, Your Honor.
And then we have clause number 26 DCCR 0433, and in that case, you're charged with a third-degree felony offense of harassment of a public servant, and that's from January 13th of 2026. And how do you plead to that charge?
I plead guilty.
And are you also pleading guilty in that case freely and voluntarily?
Yes, Your Honor.
And because you did what they charged you with?
Yes, Your Honor.
In both of those cases, I have here on the tablet some documents that have your signature on them, but the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, Your Honor.
And do you fully understand them?
Yes, Your Honor.
And do you understand if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, Your Honor.
And it looks like the agreement that you've reached in each of your cases is for a 5-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, Your Honor.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, Your Honor.
State tenders number 1 in each case?
No objection.
It's admitted in each case. Is there any evidence that Ms. Fine is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of guilty in each of your cases freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your cases, and then we'll come back later for sentencing. Before we talk about the bond, there is only a fine in 0432 of $500. There's no fine in 0433. And so, Ms. Malfino, what's the state's position with regard to
No objection.
a bond? So, Ms. Fine, what I'm going to do in each of your cases, based on the nature of your plea agreements, is reduce your bond in each case to $1,000. I'm going to make those personal bonds, which means you don't even have to pay any money. You're just going to get released from jail today. But there's some very, very important things that have to happen between now and when you come back for sentencing, if you want me to go along with this deal. The first thing is that when you are released from custody, the very first thing you do is go to the probation department. You're going to get some papers today. It's going to tell you where to go. So you have to go straight there so they can start that process to get that report from me. Okay.
Okay. Yes, Your Honor.
If you don't do that, then obviously a warrant could go out for your arrest. I don't have to follow this agreement. Things could be a whole lot worse. So it's very important that you do that. Okay.
As long as the address on it, Your Honor, I'll go.
The address will be on it. You'll talk to a probation officer in the courtroom today before you leave, and she'll tell you everything you need to know about where to go. Okay.
Okay.
The next thing is that you cannot get in any trouble or arrested for anything between now and when you come back. If you get arrested for anything, you run the risk of me raising your bond, or you'd be back in here and I don't have to follow this agreement. You understand?
Yes, Your Honor.
All right. You can go back with the bailiff. We'll
Thank
see you
you,
at sentencing.
Alrighty, friends, a couple of programming notes. First, sidebar tonight, 8 p.m. Eastern, 5 p.m. Pacific. We're going to base our discussion upon 2 child neglect cases that we've seen recently. And don't worry, at some point we'll devolve the discussion into things like food, because that's what we do. And after that, do go join Lone Wolf on his stream, 9 p.m. Eastern, 6 p.m. Pacific. I imagine we'll just redirect all of you over there. So be sure to check all of the wonderful programming out tonight that we offer. Let's do this. Step across the hall, Judge Stevens.
Yeah, people. Love it. Well, I have to, because I have to get, yeah.
He was Mountain Dew,
But he put some money down.
Oh.
Yeah, but he puts money in, so I give it to him to keep us in stock.
I'll have to pay for it after I get my 10th one.
All right.
The Medalo police officer spoke about how you go to church with American Calvary. Did they like bro? Wow, about something your lawyer this
good.
I'm not telling you for that, but they're gonna keep watching. But they spoke highly about before they investigated. I think it's. It's awesome.
What are we doing? I got a dismissal and that's 2263.
That's the 2263 is what we picked the jury on, Judge. The other matters, these other pending
So
cases.
what are we doing?
Or
What are we gonna do?
pleading guilty, the term is 10 years, probated for 10 years. Condition of that is he's gonna do the batters treatment program.
And I also have an information class here as well.
So 232263 is called the State of Texas versus Andrew Lee Lakey with his attorney and the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment? Can we proceed to summary?
Yes.
In summary, this states that on or about November 16th, 2023 in Jefferson County, Texas, you committed a third-degree felony of assault by choking. Do you understand what you're charged with?
Yes, sir.
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
Agreement's been reached. Where? You would be pleading guilty, found guilty of this crime, sentenced to 10 years in prison. That would be suspended. You would be placed on regular probation for 10 years, fined $500. There would be terms and conditions of probation, which are normal and customary for this type of offense. Is that your understanding?
Yes, sir.
What's going to happen? If I follow this, you have no right of appeal. Another device like this, because this is not working on this pad. I can't erase this thing.
No, Judge, I don't have
I
it.
can't. There's something on the pad. Okay, you won't believe this. It now just disappeared. This thing.